Well, good evening, everybody, from Delphi, Indiana. At the conclusion of day 11, our half day of trials that we have on Saturdays here in the case of state versus Richard Allen. And today is probably going to be a little different. Today is probably going to be a little different because up to this point, I've been irritated by some of the things I've seen. Yesterday, for example, the forensic analysis that's just bollocks, as our friends across the pond might say. This pseudoscience, this forcing of things to fit a narrative. That is it is a very frustrating part of defense work that we see all too often. But today is different. Today I crossed the Rubicon. Because today I'm angry. Today, what I saw in court infuriated me. It horrified me. It disgusted me. And it made me deeply ashamed. It made me deeply ashamed that this is the United States of America in 2024. And this is what is being called justice. Today we heard again from Indiana State Police Lieutenant Jerry Holeman, the lead investigator in the case against Richard Allen. And he was there to testify about Richard Allen's second interrogation, which only just conveniently realized was brought to my attention exactly 2 years ago today. On October 26, 2024, Rick Allen was interrogated and then arrested. And nothing has been the same since. I wasn't prepared for what happened. I really wasn't. I know that obviously so many of you have been following so much of this case for a long time, and I'm not brand new to it. I've read a lot of the legal filings, very familiar with the procedural background and just the positioning, the chaos, the obstruction, the gamesmanship, exclusion after hearings of critical evidence for the defense because it's not relevant. Evidence of other potential suspects, not relevant, doesn't get to be brought in. I've been familiar with all of this, but I honestly was just not prepared for what I saw from this sworn law enforcement officer on that stand today. We've seen Jerry Holeman before. This isn't the first time he's testified. He and Steve Mullen both are kind of getting chopped up. They're both allowed to be present in the courtroom there as essential participants for the state. The state needs them there, can't function without them being there in the courtroom. So they've watched this unfold. And the first time I saw Jerry Holeman testify, I thought he did pretty good. I thought he did pretty good. Now, in hindsight, maybe it's just because he followed on Sheriff Liggett, who is a train wreck, in my estimation. So maybe it was just by comparison he looked better. But the impression I had gotten at the time was that he seemed pretty reasonable. He didn't seem combative. He made reasonable concessions. It's an important part of witness credibility. If you're so resistant to the questions being asked that you deny the undeniable, it doesn't tend to make you come across as an effective witness. And that wasn't him. That wasn't him. Today it was. And more. Let's just go ahead and get into it. It wasn't nearly as long of a day today, so there won't be nearly as much to go through. I have a lot of detail. It ran out towards the end because this man became so quiet. So he was practically whispering his answers on cross-examination. A law enforcement officer has probably testified hundreds of times. Knows the gig. Knows how this works. Don't think he wanted anybody in that courtroom to hear what he had to say. Got to start off with the Brad Rosie style watch. He was a bit understated today. He didn't play any role, any active role in the case today. It was all Mr. Baldwin all the time. But Mr. Rosie was there in a black suit. He was wearing a lavender shirt with a dark blue tie, kind of a steel blue tie that had a light blue, like starburst kind of pattern to it, a modern style of a star, not like a pointed star, but like a spoke star, if that makes sense. I also noticed that the jurors have now been provided accordion files for all of their notes and the copies of the exhibits they've been provided. They've got these big, massive accordion files that they are lugging back and forth into the courtroom. Once again, last night, the jurors had access to their phones, speak with their families, so they were questioned again to verify no outside information, no media coverage. Nobody's tried to communicate with them. Mr. McLeland handled the questioning of Lieutenant Jerry Holeman. He started off reminding him that he had been present in this courtroom yesterday for Melissa Oberg's testimony. And immediately, we're on the back foot. There was a point in the cross-examination yesterday when Mr. Rosie questioned Melissa Oberg about whether she had ever told anybody in law enforcement, any of the investigators, that her techniques were about as reliable as paternity testing. Paternity testing being one of those DNA techniques where they can establish mathematically with some precision the likelihood of a certain combination of genetic alleles occurring randomly in the same way as a particular sample that's been presented. Sometimes to a degree of probability that's, 1 with 35 zeros behind it. A technique that has unparalleled precision and accuracy. Not perfect. None of them are. It's got some issues. A lot of debate around the edges of some of the stuff. But nevertheless, questioned about whether he made this comment. Well, he didn't say outright that he did, but he acknowledged that comment about her findings matching the bullet to Richard Allen's gun being as reliable as a paternity test. He said that was something that he believed, and that he shared that with other law enforcement officers. He put that out there. He concedes he understands that differently now. He explained that he remembered her saying the error rate for paternity testing is very low. So he compared those things. And he remembers from the testimony that the error rate for the cartridge comparison, right, for the bullets was about 2%. Now, this is the black box testing. It's not about comparing an unfired cartridge to a spent shell casing, one that has been fired. There's no error rate for that. He said that this was a common belief in the unified command. They all believed that this firearms comparison was as reliable as paternity testing. So that belief was perpetuated. Somebody must have made a public statement about that. And that's why this is being acknowledged, and they're trying to get past that. Because it's hard to be more misleading about the reliability of this type of technique. Another interesting concession during Mr. Rosie's cross-examination, it was brought out that somebody reported her saying, she was asked if she told anyone that after she had been provided with the cartridge, let me find what it was from last night. Let me find very specifically what that comment was from last night. This might take me a second because it was a very long cross-examination. But I want to get this version of the statement because it sounded much more like a quote from something. She certainly did acknowledge that there is no proficiency testing to compare a spent shell casing with an unfired, unspent cartridge that has been cycled about 3 times. I don't want to sit here and flip through all night, guys, and I can't find it quickly. So if I get a chance, I will get a chance because we've got a day off tomorrow. Sleep In Sunday. We are celebrating Sleep In Sunday. Although I do have some more work of a legal nature that I will need to be doing. I will give you the gist. Unfortunately, I can't find it specifically in my notes, but I will give you the gist. It was that having examined the bullet, if you are able to provide me with a Sig Sauer or a Smith & Wesson firearm, I will be able to work magic on it. That was how it was phrased during the testimony yesterday. According to Mr. Holeman, the way that Mr. McLeland put it was whether they believed that after she examined the bullet, she would be able to match it to a Sig Sauer or a Smith & Wesson. So acknowledging this comment that is pretty bad. Show me the man and I'll show you the crime. Yeah, I got this bullet. Just bring me one of these guns and I can make it work. Work magic. Sorcery. Alchemy. Yeah, that's what you get with these kinds of techniques. This subjective, unscientific technique. He seemed to acknowledge this. He seemed to acknowledge this statement. But he says, oh, he misunderstood that. He also misunderstood that. And in fact, she did link it to a Sig Sauer. Nothing to see here, people. So I'm already a bit concerned that we are starting off on this defensive footing, and then we reached the point where I knew it was going to be bad. Still not prepared for how bad it was. But that's when we started talking about Lieutenant Holeman's training in the Reid and advanced Reid interrogation techniques. We're going to have to pause here to have a few things to say about the Reid technique. Because the Reid technique is yet another unsubstantiated, unfounded, unverified procedure that, according to law enforcement, is the premier way of extracting a confession from an unwilling suspect. This has been the foremost technique that's been used, that law enforcement officers were trained in for decades. And it has rapidly fallen out of favor. Trying to remember timeline-wise when this first started to become an issue. Because this technique has raised enormous concerns about the potential, if not even the likelihood, of producing false confessions. Those of you who follow a lot of crime stories and things like that online and on social media, you might remember a recent story about a young man who confessed to killing his father. Only his father wasn't dead. That's the Reid technique. That's the type of thing the Reid technique does. Uh, JoJo mentioned last night, and I'm so grateful that she did. It's such an important reminder. The most common factors in wrongful conviction cases, in exonerations, the things that they most commonly involve: false eyewitness identification, junk science, false confessions. False confessions feature in about 30% of these exoneration cases. Thank you, Reid technique. So this technique is predicated on the idea that people who are guilty of a crime feel shame about it, and therefore they will want to relieve that shame. There's no validation for this at all. As somebody who's represented quite a lot of guilty people, not a proposition I personally would agree with. It varies, you know. Some people feel shame, but an awful lot of them don't. And especially the ones that are particularly egregious, the ones that do the kind of things that you have a hard time imagining how a human being could do that to another human being. It's lack of shame. It is a guilt presumptive model, meaning it's a technique that you use when you already think this guy is guilty, and you treat him as though he is already guilty. There's very specific stages and techniques that are used. The one that gets the most attention is the one about lying. Lying to the suspect, threatening the suspect, getting the suspect to think that it'd be better if they confess. They'll feel better. It's the morally right thing to do. Psychological and moral pressure. But very specifically, part of the technique is to lie to the person that you're interrogating about the case that you have. To try to scare them. Other developed countries, they prohibit this flatly prohibit this. The United Kingdom has prohibited police from lying to suspects since the 1980s. Not so in the Reid technique. So this has been recognized for a number of years. It has come under fire for a number of years. It remains admissible in most courts, but legislatures are starting to respond. There's good indications that people who are particularly susceptible to producing false confessions as a result of the Reid technique are juveniles and those with mental illness, those with cognitive deficiencies. So there have been states that have adopted legislation that now prohibits police from being able to lie to juveniles, to kids, lie to kids to get them to confess. They're no longer allowed to do that in some states. But this is still a minority, but it is a growing trend. Reid technique has been abandoned by a large number of law enforcement agencies and by organizations that train law enforcement agencies because they know by now you get on the stand and you testify about your Reid technique and the interrogation you performed using those techniques. And there is going to be a defense expert there telling the jury about what a deeply unreliable process this is. So law enforcement has begun to back away from this, and that's been a process that's been ongoing for about a decade. So this is not new. This is not novel. This is not something, oh, we just figured out in the last few weeks. We have known this for a long time, what a problem this technique is. But in 2022, exactly 2 years ago, this is the technique that Jerry Holeman chose to use when he interrogated Richard Allen. Because they know that it looks bad to lie to somebody when the jury is going to find out about it, they tried to get out ahead of that too. They described a little bit about the Reid technique. What do you do? Well, you try to build a little rapport. Yeah, you play all buddy-buddy first. Yeah, me and you, we're just the same. We're just the same. It's disgusting, the manipulation that this technique uses. They acknowledge that if you're going to be presenting the evidence that you have, you need to lie to them. You need to misrepresent what you have. Frankly acknowledge it. They frankly acknowledge it. Oh, the other fun part, the other really fun part about the Reid technique, yeah, body language. Body language. Body language can be helpful for a lot of things. We communicate non-verbally. I don't think there's really any question about that. And the way that we react physically can tell us a lot about what is going on with that person's internal processes. Are they uncomfortable? Are they agitated? But detecting deception, not particularly reliable. There's no magic gesture that is a sign that somebody's lying, because every person is unique. And every person is going to have a different internal process in relation to lying. Those people that we just mentioned, the ones that have no shame, that don't feel bad about lying at all, they are not going to behave the same as somebody who has a conscience and who feels guilty and ashamed when they tell a lie. Lieutenant Holeman testifies he uses these techniques often. Big part of his tool chest, the Reid technique. 2 years ago, on October 26, 2022, he interviewed Richard Allen. That interview was recorded in part, get to that, and a transcript was created. That interview took place in the Indiana State Police interview room in Lafayette. At that time, he had received Melissa Oberg's findings. He was in possession of her initial report, the certificate of analysis that she'd made, and her conclusion that the round found at the scene matched Richard Allen's gun. Steve Mullen called Richard Allen and arranged for him to show up. This was clarified to mean that, remember, they'd seized his car when they searched his home. They'd seized his car. So they told him they were going to give it back. He just needed to come down to the station, come down and get it. Seen this technique before? Yeah. When the police come and take your stuff and tell you you can come and pick it up, ready for you to have it back, authorize somebody else to go get it for you. Because this is a ploy. They don't intend to give it back to you. They intend to get you down into that station so that they can take you into one of their interview rooms and they can interrogate you, because they intend to arrest you. So give permission explicitly to somebody else to go pick up your belongings and send that person instead. That is my recommendation. The purpose of this interview was that they wanted to find out why that round was at the scene. He pinky swears that at the time they went to do this interview, the plan was not to arrest Richard Allen, and so they didn't read him his Miranda warnings. They didn't advise him of his rights. Let me repeat that. They didn't advise him of his rights. People have a lot of misconceptions about Miranda warnings. A lot of people think anytime you're arrested, it's like a part of the process, something the police have to do. It's intimately associated with that. I will have clients often who misunderstand this. Tell me, I was arrested and they didn't read me my rights. Isn't that a problem? No, Miranda warnings are only required if police are going to subject you to a custodial interrogation. So a custodial interrogation is when you are in custody, which means you are in a situation that an ordinary person would associate with being equivalent to an arrest. And so this is usually going to have hallmarks of things like you're down there in the police station, maybe you're handcuffed, your liberty is being restrained. And it's based on the subjective perspective of what a person in that situation would perceive. Not what does the officer intend. It's if you were in this situation, would you think you were just free to go? Interrogation is any questioning that is intended to elicit an incriminating response. If police are going to do one of those things, they must read you your Miranda warnings. If they don't do that, anything you tell them, it may not be admissible in court. So, generally speaking, it's far more common to over-Mirandize than it is to under-Mirandize, because it is quite risky. It's quite risky. If you're investigating a crime and somebody comes in and they provide you with all kinds of information, and that information leads you to the evidence that you need to be able to make that prosecution, but you haven't Mirandized that person, and you put them through a custodial interrogation, what they told you and the fruits of that poisonous tree, they're not admissible in court. But here, with somebody that they thought was guilty, because we're using a guilt presumptive technique. They thought he murdered Abigail Williams and Liberty German. And they brought him into the station to interrogate him, and they didn't read him his Miranda rights. What they did is they reminded him that the first time they'd spoke with him 3 days before, they read him his Miranda rights then. There's some case law about intervening time, like how long are Miranda warnings good for? Kind of put it in practical terms. And you don't have to read somebody their Miranda warnings before every question. There's some case law that suggests, you know, if you talk to somebody at the scene and you read them their Miranda warnings then, and then you take them down to the station, you don't necessarily have to reread them their Miranda warnings again at the station to continue your interrogation. But what the case law provides is that if there is a gap in time that amounts to like a change in the circumstances, something intervening has occurred, like maybe, you know, getting a search warrant and going through your house, that new Miranda warnings have to be provided. Didn't do that here. According to Lieutenant Holeman, the door wasn't locked and he was free to leave. At one point in time, Detective Vito came in, but it was usually just one officer in the room. I want you to put yourself in the back of a police station. You've gone through a few secured doors now. Somebody's had to key swipe you in to these secured areas. You've gone down some hallways and made some turns, and you've been led into a small, windowless interrogation room. There's a chair, there's a desk, there's cameras in the corners. There might be a window with two-way glass in it. You can't see the people on the other side, but they can see you, and you suspect that they're there. There's a law enforcement officer sitting at the table behind you. You may or may not be able to get directly to the door. And now this law enforcement officer is accusing you of a horrible crime, telling you, I quote, "I fucking know you did it." You gonna just walk up and leave? You're gonna feel free to leave? Walk past that officer, out that door, down those halls, through those secured areas, out the front door, and go about your day? That seem reasonable to you? In this rapport building stage of the interview, Lieutenant Holeman asked him if he'd had any property damage during the search. So sorry about that. So unfortunate. I hope it wasn't too inconvenient. I hope we didn't damage anything. Here's the claim form that you can fill out. If we accidentally broke anything, or maybe we stained your carpet, or all that digging we did in your front yard destroyed your landscaping. Yeah, sorry about that. Here's the damage form. Oh, and by the way, I heard you're a military guy. I'm a military guy too. They talked about their experience in the armed forces. Part of this rapport building. They talked about their guns. Talked about the guns they'd had at military, had as military guys. Lieutenant Holeman said, if I could build an indoor range, I'd shoot every day. And he asked if Mr. Allen shot his gun very often. Not very often, Mr. Allen said. The interview then entered the confrontation stage. And at this point, Lieutenant Holeman showed Mr. Allen Ms. Oberg's results and confronted him about why his bullet was at the scene. Asked him for possible explanations. This is part of the Reid technique. You invite them to provide you with alternative explanations. Maybe you loaned out your gun. Sometimes people loan out their property. Lieutenant Holeman testified he provided examples about all these things to really humanize how perfectly normal it would be if you had loaned out your car to somebody. What they're doing is they're trying to get you to concede that your car was at the scene, that you would place it there and save them the difficulty of having to prove it, which is what a false confession does. If they can get you to implicate yourself, it will save them the trouble of having a case. They don't have to find the evidence and preserve it and present it and properly analyze it. If they can just get you to implicate yourself. So he asked if he'd loaned out his car, loan out your clothes sometimes, somebody maybe at your house, maybe the weather turned and they needed a coat and you gave them that blue Carhartt jacket. What about that gun? Sometimes people loan out their guns. Can't do that in Washington anymore. Well, gun laws are way up in the air right now after the Bruin decision. That's a whole sidetrack I'm not going down right now. Don't know if it's legal to loan out your guns in Indiana, but I'm going to presume it is because the gun laws seem pretty permissive. We'd heard from Melissa Oberg yesterday, although she's not an expert about the gun laws and things like that, is generally allowed in Indiana to shoot your guns out in the country. Pretty permissive about stuff like that. Rick said he had never loaned out his gun. So they reviewed his statement about where he was at on February the 13th of 2017 and asked if he'd had his firearm with him. If he carried his firearm, did he regularly carry his firearm with him? And he said no, he did not regularly carry his firearm with him. He only carried it when he was out fishing or mushroom hunting. And he didn't have it that day. So at this point, Lieutenant Holeman told him, we have a report from the lab saying that your gun matched a round found 6 inches from a dead girl's foot. Do you think if you're innocent and somebody accused you of that and is asking you this question, that it might make you agitated? might make you nervous. I think most people who are innocent in that situation are going to wonder, what's going on here? Mr. Allen denied it and couldn't explain how it got there. Well, no shit, he couldn't explain how it got there. This is supposed to be indicative of guilt? According to Lieutenant Holeman, his demeanor at the early part of this interview, the rapport building stage, when we're just good buddies chit-chatting about our military experience and our guns, he had a very normal demeanor, but that changed. That after Lieutenant Holeman confronted him several times, he became more agitated. Remember how part of the Reid technique is about trying to interpret body language? They will read getting upset about being wrongly accused of something as a sign of guilt. It means you're guilty. According to the Reid technique, innocent people don't get upset about things like that. They just stay calm because they know they're innocent. Does that ring true to you? Needless to say, as I've already said, there is no scientific foundation for this assumption whatsoever. None at all. But that's the technique, and that's the thought process. You get upset when you're accused, that means you're guilty. Still at this time, Lieutenant Holeman insists he was not under arrest at this time, and they had not made the decision to arrest him at this time. We revisited the comment that Mr. Allen had made during the search of his home that had concerned Lieutenant Holeman so greatly that we heard about when he did testify the first time and seemingly came across pretty good, I thought, about how it doesn't matter, it's over. So Lieutenant Holeman asked him what he meant when he said that. And he said what he meant by it's over is that the damage was done. They had interviewed all his neighbors. They had interviewed his coworkers. Everybody already thought he had murdered those little girls. And his life was over. Does that seem reasonable? Police are asking everybody you know about where you were the afternoon 2 little girls were murdered. Have they ever seen you act weird towards little girls? Have they ever seen you do anything creepy or strange? Asking everybody you know what they know that might connect you with these murders. Think that might ruin your life? Well, not to Lieutenant Holeman, because according to him, they hadn't publicly announced any arrest at this point. How could your life be ruined? We haven't done anything formal. We've only just planted all of the seeds for your entire little small community to turn on you. That's all. We haven't, officially done anything. At this point, they took a break. They gave him water. You take a little break. Part of the Reid technique. Part of the Reid technique. Asked him if he wanted a smoke break because they know he smokes. You're going to be very accommodating. Why don't you take the smoke break? You can stop and think about it. About what we've talked about here. Then when they resumed the interview, the interrogation, should stop being so generous and calling this an interview. When they resumed the interrogation, now they talked about the video that was found on Libby's phone, the video of Bridge Guy, and the voice on that video. So this is where Lieutenant Holeman acknowledges lying to Richard Allen when he told him that they had witnesses out there who could ID him and experts who said that it was him and his voice on the video. Acknowledged. Yep. No shame at all. Lied to him because that's an approved technique. It's okay. It's a thing that law enforcement officers do. You know, the thing about lying becomes a slippery slope. I've tried to live my life on a position of radical honesty, like white lies, A lie is a lie. And the problem is once you start lying, it gets easier. It's just like any habit that you can build. And that initial shame, discomfort, self-loathing you might feel because you know that you're lying. You know that you're lying. You get numb to it. And it just becomes an easier and easier thing to do. This is, from my perspective, a significant root of the rot that has infested so many law enforcement agencies. Because if you can lie in the interrogation room, it's a pretty easy step to you can lie in court. You can lie in your affidavits. You can lie to a judge. The whole premise is that the ends justify the means. It's okay to do this immoral thing because at the end of the day, the outcome is good. That's what they think. Because in this mindset, there's good guys and bad guys, people that wear the white hats and people that wear the black hats. And as long as you're one of the guys who wears the white hats, anything you do is good. It might look bad, but your intentions are pure and noble. So lying gets easier and easier because in your mind, you're the good guy. You're just trying to catch these bad guys. And you know, sometimes the system, it just gets in the way of your ability to do that. You can do better crime solving. You can put more bad guys away if you just go ahead and bend the rules around the edges. We have the United States Supreme Court to thank for this because it was in Frazier versus Cupp back in the 1960s that the U.S. Supreme Court held totally fine for police to lie to people in an interrogation. Totally fine. We don't love it, but not going to say that's coercive. Look where we are today. Look where we are today. Trust in our institutions is at an all-time low. It seems like every time we turn around, there's more information about corruption. Just more and more instances of bad actors in law enforcement. And it's so depressing. It's so sad because probably most of us know some really good cops. Know police officers who are really good people and who really do. They're helpers. You don't go into law enforcement because it's going to be big money and people are going to love you and it's going to be prestigious and the hours are good and the pay is great. You know, you don't go into law enforcement for these reasons. People go into law enforcement because they're helpers. They want to help people. And there's so many of those people. And the system is so poisoned and it's so corrupt. And it's just so sad to see the good people get caught up in that. Richard Allen never explained how his bullet came from the crime scene. Just insisted it didn't come from his gun. They asked him if he ever committed the offenses. He said no every time. He denied murdering the girls 20 to 25 times during this interview. Part of the Reid technique is that when they deny, you interrupt them. You don't let them get it out, you cut them off. You disrespect their denial. You treat it with contempt. It's not even worth listening to. "20 to 25 times he denied murdering the girls. He denied having his gun on the trail. He had no explanation for his bullet at the scene. He was asked if he'd ever been in the area where the girls were found, that part of the woods. He said no. Mr. Allen then told them about his mental health issues he had dealt with in the past, that he had suffered from depression and anxiety. They knew when they arrested this man and took him away from his family and threw him into solitary confinement for a year and a half, they knew when they did that, that this man was mentally fragile. It gets worse. Well, as part of Lieutenant Holeman's training in interrogation techniques, one of the training modules he described going through involved being able to recognize mental illness, individuals in crisis, and be able to talk to them. This is talking about dealing with people who are usually suffering from some kind of psychosis, schizophrenia, a bipolar disorder, some type of mania. Ways that you can communicate that will be calming, because these conditions can produce a lot of agitation. One of the things that can be really helpful is to offer them a cigarette. I remember hearing stories from my better half at home, who used to work with the involuntary commitments, the folks who are being detained against their will because they suffer from some kind of mental disorder. They're having a hard time. They're in crisis, and I remember being told that a lot of these individuals, they would go ahead and not contest. They would not contest being detained because if they agreed to the long-term commitment, it would get them out of the local county psychiatric hospital, and it would get them to the state hospital. And at the state hospital, they were allowed to smoke. A lot of people with severe mental illness smoke, and it's a very calming thing for them. I wonder if he was taught that. Anyway, based on that training to detect mental illness, he didn't observe any obvious signs of mental health issues in Mr. Allen at the time. Yeah, no shit. Because he wasn't in crisis at this time. That didn't happen till later. His demeanor changed throughout the interview as Lieutenant Holeman asked him 20 to 25 times about whether he committed the crime, and he became agitated. Yeah, his demeanor changed and he became agitated. Guilty! Lock him up! He's upset that 25 times you've accused him of murdering 2 little girls when he's telling you, I didn't do it. And that means he's guilty. He denied ever firing his gun on the property around the bridge. He continued to deny involvement. He said, I'm not going to tell you I did something I didn't do. In fact, he said, I don't care what you do to me. I'm never going to tell you I did something I didn't. As soon as I heard that, knowing what unfolded in this case, I realized these investigators, they took that as a dare. I dare you to make me tell you something I didn't do. That's how they took it. He denied contacting or knowing Abby and Libby. Again, he continued to become agitated, and so the conversation got heated. At one point, Mr. Allen said he was pissed off he didn't fucking do it. And at this point, according to Lieutenant Holeman, he then raised his voice back and cussed at him in return. And he did this because he normally tries to match their demeanor and use their language. So if that's the language that they understand, then that's what he'll adopt and use. That's the only reason. That's the only reason why this interview transcript shows him cursing like a madman at Richard Allen. I know you fucking did it. That's the only reason why. He thought that's the language that Mr. Allen would understand, to yell at him back and curse at him repeatedly. Remember, we're not supposed to see any of this. These interviews, Mr. Baldwin had already suggested we'd be able to see all this. If we saw the interview, it would be the best source of it. And Lieutenant Holeman said, yeah, it would. Weird the state didn't show him to us, isn't it? Weird that we're sitting here listening to Detective Holeman or Lieutenant Holeman tell us about it instead of just watching it for ourselves. Remember? We're not supposed to see any of this. He asked him again about loaning out the gun, and he gave no different answer. And he never offered any explanation about how the bullet cycled through his gun got to the scene. At this point, Mr. Baldwin objects to him calling it the bullet cycled through his gun. Mr. McLeland says, well, that's what the expert said yesterday. It's perfectly legitimate for them to characterize it as the bullet that was cycled through his gun. So Mr. Baldwin asks to approach. Here's the problem. I already know what this problem is. You are not supposed to be opining on the witness's guilt. The jury gets to decide whether the bullet cycled through his gun. Not Ms. Oberg, not Mr. McLeland, and not Lieutenant Holeman. The jury gets to decide. And it appears that this was well taken, because when they came back, Mr. McLeland rephrased his questions. You were there for Ms. Oberg's testimony, and you understood her belief was that the bullet was cycled through his gun, and you believed that, and what you were confronting him was your belief. And he had the certificate of analysis, yes. He certainly believed it, and he used those findings to confront him. And he never explained it. The answer that he gave was that there's no way that round cycled through my gun. And when he was asked how his bullet got to the scene, of course, he didn't have an explanation. We said this probably a dozen times throughout the course of this direct examination. The same thing over and over and over again, as if this is incriminating. There's a reason why the defense isn't objecting to this being asked and answered for the 10th time. He doesn't have an explanation for why they would think his bullet got to the scene. And here's the thing. Rick Allen held up so well under this interrogation at this stage of the process because the purpose here is to get him to come up with some explanation. Well, maybe I was out there and implicate yourself. Tie himself to it. Admit that it could be his. And then they will turn around and treat that as consciousness of guilt because you're trying to distance yourself. Trying to minimize it. Under these rules that Indiana seems to allow in court that probably allow him to testify, I thought it was a ridiculous excuse. Seems like that's okay in these courts. In my opinion, it was bullshit. That's what they're trying to do. They're trying to get something like that so that they can make him look squirrely, make him look like he's guilty and trying to scramble and come up with explanations for things. So maybe that's why Lieutenant Holeman was so mad in this interview because Rick Allen held up extraordinarily well under this pressure, and he didn't give them that. He gave them nothing to work with. They asked if he was out on the trail that day. He said he was, and he already told us he was. And the same thing about being on the bridge. He already told them he was on the bridge. Wearing what? He already told you what he was wearing, and he told them that. They took another break, and then they continued the interview. During this break, they allowed, remember, he's free to leave this whole time, but they allowed him to speak with his wife. That a little slip there? They let him speak with Kathy, but they monitored it. They were there listening. And he's asked, did anything stick out about that conversation? Here's what stuck out about that conversation. Rick Allen told his wife, all you have to do is ask for a lawyer and they have to let you go. Don't worry about me. He told his wife to protect herself and not worry about him. Apparently, this is deeply concerning and incriminating. The man loves his wife, and he sees what's happening, and he wants to keep her safe. When he was asked how he carried his gun, he said he had a side holster for his belt. Asked if he usually carried around in the chamber. This is just different practice. People who carry their firearms, some people say load it in the chamber so that it's always ready to fire, because if you need it, you don't want to have, you don't want it to take any extra time to be prepared to use that gun. Other people think, well, it's not going to take super long to chamber a round, and it's less safe if a round is in the chamber because it means the gun is that much more ready to fire. And so there's just a greater possibility of some kind of accidental discharge. Accidentally, the safety is bumped up against something and you accidentally pull the trigger. Some of these semi-automatic firearms have extremely light trigger pulls. So they rely on other safety mechanisms, but there could be issues with that. So if a round is in the chamber, the gun is potentially more unsafe. So people have different practices with that. It's just a matter of preference. He thought he usually carried his gun with a round in the chamber. This would be a little bit of a problem. Remember investigator Mullins's interpretation of that enhanced video and the things that were said? And according to him, when there's the interaction with Bridge Guy at the end of the trail, Libby says, "That be a gun." And then they hear a sound that he describes as a gun racking. The slide being racked back. If the gun is in the, if the gun is, there's a round in the chamber, then that's going to discharge the round right there. Not down there at the crime scene. There would have been a round up there at the bridge. They didn't find a round up there at the bridge. Probably to them, this is proof that Mr. Allen is lying, about carrying one in the chamber. Still at this point, Mr. Allen is not under arrest, even though police are controlling the environment and whether he has access to his wife. And still, no, they hadn't decided to arrest him yet. Nope. Still not sure which way this is going to go. Using our guilt presumptive technique where we're yelling at him, "I know you fucking did it." But they weren't sure. They weren't sure which way they were going to go. He gave no indication that he knew the girls, that he murdered the girls, that he carried his firearm on the trail, or how his round was found between them. So now what happened in court? Now what happened in court disgusted me. Disgusted me. I am beyond shocked that this is allowed in the state of Indiana. This would unequivocally not only not be allowed in my jurisdiction, this would be prosecutorial misconduct. This would be the kind of thing that would get a mistrial and the case would be tossed because it is flagrant. This is the kind of thing that would get a bar complaint. This is the kind of thing that, even though it almost never happens, if there's an appeal, you might actually get the prosecutor's name in the opinion, reversing the conviction. Mr. McLeland asks, based on your training and expertise, are you able to identify when a suspect is being deceptive? Oh, yes, indeed. Sometimes he is. Remember that Reid technique training that he's gone through with its focus on body language? What are some of the things he looks for? Well, he's not an expert. There's many things. And he just has an awful lot of training and experience with lying suspects. But he uses this Reid technique to pick up on clues. And that's what he did in this interview. So Mr. McLeland is allowed to ask, did you pick up on any clues that Mr. Allen was being deceptive in this interview? Mr. Baldwin objects at this point to the foundation for this answer based on the fact that Lieutenant Holeman had already said, I'm not an expert. How do you detect deception? Well, I'm not an expert. Yeah, no, you're not. Nobody is. So he was allowed to ask some preliminary questions. They call it here. We would call it voir direing the witness. They use preliminary questions. So they asked about what are some of these indicators? Some of these signs that somebody is being deceptive. And Lieutenant Holeman says, well, he's not sure if this specifically came from his Reid training because he has had Reid training, but he remembers being told that touching your face, looking down, or looking away, these can be signs of deception. I'm a face toucher. I'm a face toucher. The face touching is going to be a self-comforting gesture. It's a sign that you're agitated. I'm a little agitated tonight. I'm angry. I'm angry. I am furious at what they did and at how they are allowed not just put their finger on the scale in this courtroom, but to slam their fist into it. To act like they're experts who can testify that somebody is lying because they touched their face. This is on par with that fresh guilt scent story I told yesterday about the Washington Supreme Court finally put some, or it was a Court of Appeals, but finally put some limits on junk science in Washington. That was the bridge too far. Your fresh guilt scent. Touching your face means you're lying. This is on that level. This is on that level. Being allowed in a courtroom to be able to say that guy's lying, he's guilty. I'm the expert. I'm the investigator. I have all the authority and prestige of the state behind me. And people look to my office as something that they should trust. They expect integrity from me. They project that onto me by virtue of the position that I hold. And I can leverage all of that influence and the high regard that the jurors are going to have for members of law enforcement, and I can abuse that and manipulate that to try to persuade them that I'm some expert in who's lying and who isn't, based on whether they touched their face. I am blown away by this, that in 2024, in the United States of America, that this is happening in a court of law. I am dumbfounded. Mr. Baldwin is also dumbfounded. How and why does touching your face indicate deception? And Lieutenant Holeman answers, I don't remember. It's just something somebody told me. Somebody told me. Therefore, I'm an expert. Same thing about looking down or not making eye contact. Who told you? Who told you that? How does that indicate deception? He doesn't remember. He doesn't remember what that training was or what the credentials were or who told him. He doesn't remember. He just remembers he's been trained. He's been trained that that's the case. Absolutely no foundation for this opinion at all. That objection is overruled. And so, the signs of deception that Lieutenant Holeman testified to, he says, they're subtle, there's nothing obvious. They were subtle things. His denial. Got that? Saying you didn't do it is a sign of deception because they've decided you have. So if you are going against them, you must be lying about it. Denial is a sign of deception. He denied. He touched his face. He looked down, and sometimes he didn't make eye contact. So these were very subtle signs, very subtle. How many conversations do you have with people where you never break eye contact? Think about that. Think about those conversations, and if you guys are just staring at each other, unbroken, for like 10 minutes, that seem normal? Seems creepy as hell to me. If somebody is staring, eyeballing me down and never looks away, never breaks eye contact, that's not normal. This is horseshit. I try to keep my stream clean, guys. I really do. My grandma watches sometimes. But this is so upsetting. This is so upsetting. I just can't believe. I can't believe what I saw today. Now, he's quick to acknowledge that not every single person who denies their guilt or touches their face is deceptive. Not every single one. So we're to take it that he has the expertise to be able to know when touching your face means you're lying and when touching your face doesn't mean you're lying. When a cigar is just a cigar. But according to Lieutenant Holeman, it was these things: touching his face, looking down, and not making eye contact sometimes. These things plus some comments stuck out to him. So what was the comment that stuck out to Lieutenant Holeman? Well, when he looked at Mr. Holeman and said, "I don't think you and your wife are bad people. I don't think you're a bad guy." Mr. Allen said, "What kind of a good guy would murder two girls?" Is that not a fair question? Is that not a fair question? You're sitting here telling me at least 25 times that I murdered two girls. But you're trying to tell me I'm a good guy? How does that compute? Is that not a fair question? What a setup. What an absolute setup. There was no way that Mr. Allen could do anything right in this interview. Pardon me, in this interrogation. He was never going to be able to do anything right. It didn't matter what he did. It was going to be construed against him because by walking in with the intention to use the Reid technique, they already presumed he was guilty. And whatever he did was going to be read as confirmation of that. What kind of good guy would murder two girls? Lieutenant Holeman reiterates, of course, they had breaks, and of course, he wasn't under arrest. And he never ended the interview. Everything must have been okay. Now, he said, "I'm done," a couple of times. Said, "I'm done." But then he continued to talk. Remember, because that door is closed and the police officer might be sitting between you and the door, and you got to go back down that hallway and through those secured areas in the police department. You got to do that of your own accord to terminate this interview. Everybody's super comfortable with that. So they just keep questioning him, is what happens. He says, "I'm done," and they ignore him. They continue to interrogate him. Some people wonder why "I'm done" wouldn't be invoking your right to remain silent. Right? I'm done talking to you. I have the right to remain silent. And once you invoke your rights in an interview, your invocation must be scrupulously honored. Or anything subsequent to your invocation may potentially be excluded in a court of law. On this particular issue, what they do is they hang their hat on case law that requires that an invocation must be clear and unequivocal. It can't be wishy-washy. Can't be ambiguous. "I'm done." I'm done. Well, but I'm done what? I can already read the opinion. I really can. I can already read the opinion justifying continuing to interrogate him when he has said a few times, I'm done, and you keep hammering at him. Well, he didn't say I'm done talking. He didn't say I want to exercise my rights. He didn't say I'm going to stay silent now. I'm terminating this interview. Didn't say it. So, maybe it's equivocal. Maybe it's ambiguous. Several times he said he's done, and they continued to hammer him. It got more heated. I told him I thought he did it. And he said, then take all your evidence and arrest me. So at this point, they stopped talking. Now, what additional incriminating evidence have they gotten from this interrogation beyond what they already had when they walked into that interrogation room? Absolutely nothing. They got nothing. They just got this horse shit about him touching his face. Looks like he's being deceptive. He said these things that were weird and suspicious. But he denied committing these murders 20 to 25 times. And he was resolute, and he did not change his story, and he was consistent throughout, despite the hammering. But at this point, Lieutenant Holeman left and conferred with some of the other investigators. And at that point, they decided to arrest him. Why? Why did they decide to arrest him? Well, because at that point, they thought they had enough evidence to establish probable cause. Nothing new. Since the time he walked in that interview room when they insist, he's not under arrest. We have no intention to arrest him. Nope, that's not what this is about. Got absolutely nothing and arrested him. Yeah. He was never going to get his car, guys. Don't do it. They call you to come get your property. This is what they want to do. I'm horrified. I'm horrified. I'm appalled. I'm disgusted. I'm angry. And I'm particularly infuriated that the entire world did not get to see this. This is the direct examination that was this bad. Then we got to cross. Andrew Baldwin handled the cross-examination. And his opening question was, Lieutenant Holeman, I saw you looking down quite a bit during your testimony. Is that a sign of deception? Boom! Boom! This cross-exam, this was a masterclass. This was a masterclass. This was Mr. Baldwin doing some extraordinarily fine lawyering. We've seen Mr. Baldwin get upset before in this case, get maybe a little testy. Let that show. And I have no doubt that Mr. Baldwin is just as infuriated as I am, probably more, probably a lot more, about the treatment of his client and this one-sided, unfair court process that at this point, it seems like they are going out of their way to give the state every possible advantage and to hobble the defense. They have a Sisyphean task in this trial. And I am confident that the responsibility of that is an overwhelming burden for this defense team. One of the hardest things that you do as a defense lawyer is defend innocent people. Defending guilty people is very easy. People always ask the question, Andrea, as a criminal defense lawyer, how do you defend those people? And the answer is it's very easy, because most of the time, when you're dealing with defending a guilty person, your job isn't to try to pretend they're innocent. Your job is to evaluate, are they being treated fairly? Are they charged with the right crime? Have they been overcharged? Is the sentencing that the prosecutor wants to recommend, is that appropriate? Should there be some kind of mitigating circumstance the judge should consider? Should they be eligible for some kind of alternative sentence, like treatment? Probation? Did the police violate their rights in order to make this case against him? Because if the police will violate his rights, they'll violate yours too. So we draw a hard line when it comes to protecting our rights to privacy. This is America, and the police don't get to just walk in your front door and go into your bedroom, poke through your dresser, look through your phone. No. They need a warrant based on probable cause. That's the job when you protect guilty people, and oh, there's responsibilities with it, certainly, because most people who have committed crimes, they're not monsters. I can count on one hand out of thousands of clients that I have represented. I can count on one hand the number of monsters in human skin. Most criminals are not that. And I guess maybe it's just part of my nature that I always try to look for the good in people. Very few people are irredeemably bad. If we believe that people are irredeemably bad, why do we even have the system? Are we to just lock away everybody and throw away the key? We have to believe in redemption. Or what are we even doing here? Redemption is supposed to be what this is all about. Why we have the system, so that people can take their punishment and do better. So there's a heavy responsibility because you see the good in somebody and you see the injustice of the system. And yeah, you get outcomes that are bad outcomes, and those weigh on you. Those weigh on you. And when you're a public defender and you got a billion cases, you're overworked, you don't have time to do all the things that you would like to do with these cases that you feel like you should do to be effective, to be thorough, to make sure the process is fair. You get that unjust result, and what do you do? Do you get time to process that, to grieve? No, because you got to be down at the jail in like 20 minutes to interview your next client. But the real heavy burden is when you have a client that is innocent. Because that's when the responsibility is so heavy, because the consequences, the magnitude is so great. Not just for that person, but everybody who loves that person is affected by that injustice. And they are all looking to you. You're their only hope. The burden is enormous. And so I know to my core how this is weighing on Mr. Baldwin, because he believes his client is innocent. And yet, in this cross-examination, he didn't get angry. He didn't get upset. He's just seemed almost just disappointed, just sad that we had to be doing this. He pointed to Mr. Allen and said, "This guy right here is not the same guy you experienced." Mr. Allen today, 2 years ago, he's not the same as he was. And we're going to see that. We're going to see what they did to this man over the last 2 years to change him. And he'll never be the same. You can't come back from an accusation like this. There's no going back to before. You were accused, imprisoned, and put on trial for brutally murdering 2 little girls. Mr. Baldwin said that you reminded him of his rights and said that he was free to leave, and pointed out that that was important because if you didn't, that would render this interrogation constitutionally suspect. If they hadn't reminded him of his Miranda rights, game over. As far as had Mr. Allen, what if he had confessed? What if he had walked in and he'd confessed? You haven't read him his rights or reminded him? Yeah, big problem. Big problem. That whole quest for justice for Abby and Libby, you just made it a lot harder with that decision. So very important. Because yeah, you didn't do that. The whole thing, this is constitutionally suspect. But lo and behold, that part of the interview where Lieutenant Holeman says he reminded Mr. Allen of his rights, it's missing from the video. Remember, this entire interview was video recorded? Yeah, not that part. That part's missing. Yes, Lieutenant Holeman says, we had technical issues. More technical issues. He said that he went outside the room and somebody was able to get it working. Well, apparently, in his deposition, he said specifically that he saw 3 dots that said it was recording with his own eyes. And that's why he thought it was recording. So he explains, there's a delay. It looks like it's recording. You can see the dots, but there's a delay. So the video doesn't actually start until after they walk in the room. At this point in the cross-examination, Lieutenant Holeman is still feeling pretty good about how things are going. And he's one of these law enforcement officers that likes to turn and talk to the jury. And he's got this expression that I can really only describe it as, it reminds me of Troy McClure. Hi, I'm Troy McClure. You may remember me from some such botched investigations as losing all of the recorded witness interviews in February of 2017 and not remembering to turn on my recorder in my police car when I have the suspect telling me incriminating things. Just that flash. That's how he looks at the jury. And at this point, that's what he does. He's given this explanation. Oh, there was a delay. That attitude doesn't last. And he concedes, yes, the video doesn't show him reminding Mr. Allen of his rights. That's correct. That part, that's not on the video. Yeah, they had lots of technical issues because now we reminded him of all of those missing videos from February to May of 2017. All the witnesses interviewed. This is what came out during the pretrial litigation. The motion to suppress for Brady for failing to preserve evidence. Countless witness interviews from the early stage of the investigation. Just gone. Gone. The explanation, technical issues. Technical issues, they just didn't realize that these interviews, they weren't being retained. They were being recorded over. What was weird is that I seem to recall that there was like a gap in time where it worked again, but then the technical issues resumed. I think it might be worth hiring a tech person to get on top of that maybe the first time it happens. Nope. Because 5 years later, in 2022, nope, we're still having these inexplicable video glitches. So unfortunate. Mr. McLeland objected to that line of questioning about the lost videos because it's beyond the scope of the direct, and that was sustained. So, according to Mr. Baldwin, we have to take your word that you advised Mr. Allen of his rights. And Jerry Holeman says mine and the witnesses that were there that day. Does that Troy McClure grin at the jury? Yeah, these law enforcement witnesses that now I feel like everybody is wondering who we can trust. Can we trust any of them? These witnesses? In discussing the demeanor changes that were very important to Mr. Holeman, he points out that Lieutenant Holeman agrees that yes, there were similar demeanor changes that Investigator Mullen described during his interrogation. Yeah, the demeanor changes. Turns out they might have put their foot in it. Because they don't want those videos in. That has become abundantly clear. They're not offering them. Mr. Baldwin has already put it out there. Jury, this would be great if you could see it. And everybody agrees, but it's not being shown to them. Well, they kind of put their foot in it with all this testimony about the demeanor changes. Because now they've opened the door. They've opened the door to see his demeanor for themselves. So Mr. Baldwin moved to admit the videos. Mr. McLeland jumped up. We need a sidebar. They had their sidebar. And at this point, Mr. Holeman, he's left alone on the stand because the judge and the attorneys, they've gone over into their little corner behind the screen and the white noise is on. And so I'm watching Lieutenant Holeman at this point in time. And he's still kind of trying to do his little Troy McClure thing at the jury. But don't think he liked the response he was getting because he didn't keep it up. Yeah, he started to break eye contact. Sign of deception. He didn't sit there and eyeball those jurors for the entire time. Must be being deceptive. He looked down, looked away. Sitting there with a little like half smirk, you know, on the stand, the little half smirk, because you know you're caught. The smirk of the people that know they're caught. We're all familiar with that. Everybody's seen that. Everybody's seen that. I'll tell you real quick my story about the smirk. I've told it before on my channel, but there's been a lot of new people show up. It was a case I had that was a break and entering. Folks woke up in their home about 2:30 in the morning. They're hearing somebody trying to break in through their back door. So the gentleman, he grabs his shotgun and he goes downstairs and he confronts. He sees the person. They have like basically the screen door open and they are trying to kick down the back door. So he sees the person and confronts him with a shotgun, and the person runs away. About 3 hours later, 2 hours later, maybe somewhere in there, very late night / early morning hours, my client is arrested for walking around in the neighborhood. He says he's been at a party at a friend's house nearby, and he's just on his way home. Nothing to do with it. But they do a show up, where they it's not a lineup. It's far more suggestive than a lineup. They took the couple that had the house broken into, took them to where he was. They said, yes, that is the guy. So he's charged. He's charged with residential burglary. This is a Class B felony in Washington. It's a strike offense. Very serious charge. Client is adamant he did not do it. He was at a party. He's got names. People who will confirm. Just walking home, wrong place, wrong time, and mistaken interview, or mistaken identification. So we're pursuing this. We're looking into his defense. When lo and behold, I get a supplemental police report. Shows up on my desk. So this had happened in about February, and there was snow on the ground at the time. But then we had a little bit of a warm spell. We have these what we call Chinooks up in the Northwest. They're such a blessing. In like January, February, you'll get these warm winds that come through that are like 70 degrees, and it's just like this. It's so wonderful. You get sunshine, and it feels fantastic. It feels like spring is coming, and it will melt like all the snow on the ground in hours. So the snow melted, and lo and behold, there's a cell phone right there on the stoop. So they take it to the police. The police plug it into their machine. They crack it. Whose do you think it is? It's my client's. So we have a little sit down. In my office. And we go over. You're at the party. Who should I talk to? Oh, how are we going to deal with this? Hand him the supplemental report. How are we going to deal with them finding your phone on the stoop? I saw the smirk. And the client asked, is the plea still on the table? The plea deal? That's my story about the smirk. We've all seen it. We all seen it. I saw it on the stand today. When they came back from the sidebar, Judge Gohl admitted the videos, but they're not going to be shown at that time. They're going to be shown at a different time. Not entirely sure why, but they're going to come in now. We're going to get to see these videos now. And they're going to be exhibits. So when the judge decides to follow the rules on public access to court records, those will be public available, and we will all be able to see them. So I am going to be watching those very closely. Very closely. And I imagine the jury will be too. And I imagine they're not going to make the state look good. Because if they made the state look good, they would have shown them. We took a recess at that time. And then when we came back, they had another sidebar. Mr. Baldwin, again, he wanted to pre-clear his questions with the court. See, they are aware that the process is one-sided, that the rules are not the same for the state as they are for the defense. And so the defense has been chastised for their questions, Mr. Baldwin in particular. Just a couple days ago, he came out all blazing, you know, accusing the witness of lying to the jury because they're so desperate to have that car on the Hoosier Harvest Store video be Mr. Allen's car. So he knows that he's got a high risk of pretty much, you know, he's got to stay very far on the not challenging side of the line, or he's going to get admonished in front of the jury. And then that makes it look like he's doing something wrong by trying to do his job. So they have the sidebar because he wants to pre-clear his questions that he thinks they are appropriate, but he doesn't want that. He doesn't want the judge getting on his case in front of the jury. So when they came out, Mr. Baldwin said, you talked about one of the lies, one lie you told Mr. Allen during direct examination. And Lieutenant Holeman said there were actually two lies that he told. The first was that witnesses had seen him on the trail, and the second was that the expert said it was him and his voice on the video. Those were the two lies. Mr. Baldwin elicited that Mr. Holeman even told him, I'm not lying about anything. Lied about lying. So it's not just two lies. You also lied about lying to him. And according to Mr. Baldwin, he also said it would be unethical for me to lie to you. And Mr. Lieutenant Holeman denied that. He says that doesn't sound like something that I would normally say. But then it's you know, it's read from the transcript what he said. He told him that other investigators wanted to lock him up and throw away the key. These are things Lieutenant Holeman told Mr. Allen. Other investigators wanted to lock you up and throw away the key. Told him the death penalty is on the table, to which his response was, I don't care, kill me. Lieutenant Holeman told him, I'll say it the way Mr. Baldwin said it, which is not the way that Lieutenant Holeman said it, pretty sure. You're going to drag your effing wife and daughter into this because you're too effing bullheaded to get out in front of it. Brings his wife and daughter into it. He's a bad guy for not confessing because guess what? Implied threat. That's going to make things real tough for your wife and daughter. Nice wife and daughter you got there. Shame if something happened to them. All because you didn't confess. This is about the point when Lieutenant Holeman drops the Troy McClure routine. And he starts getting quiet. By the time we're done with this cross-examination, Lieutenant Holeman is answering the questions about like this. This is his tone. We're straining to hear him in the courtroom. I can't imagine the jury isn't straining to hear what he's saying. So quiet. Like he doesn't want anyone to hear it. Not so proud now. Mr. Baldwin asks, it must have been important to you to get a confession out of Richard Allen. And Lieutenant Holeman, no, insists these are tactics. These are perfectly acceptable tactics that are used to elicit responses. To elicit responses. He got responses, and those responses weren't good enough. So they hammered at him 25 times after he said he was done, over and over. Just tactics, just to elicit responses. We're just educating ourselves here. It's just a tactic to leverage his wife and daughter and say that they were going to suffer if he didn't confess? Oh, no. Lieutenant Holeman says, that's not what I meant. That's not what I intended by that. That wasn't my meaning at all. What alternative meaning is there? You're going to drag your effing wife and daughter into this because you're too effing bullheaded to get out in front of this. What other interpretation is there besides your wife and daughter are going to be involved if you don't confess? They're going to be dragged in. Does that sound like a pleasant thing that they're going to enjoy? That this is going to be a beneficial thing for their family, a positive experience? No, that's not what he meant. We revisited then during Investigator Mullins' testimony, which of course Lieutenant Holeman has been present for, that Richard Allen said he didn't know which way he drove. That was what they said, that he didn't know which way that he drove. And according to Lieutenant Holeman, he said there were multiple ways he could have gone. They're still insisting that they're right when we heard, we got the transcript. We got the transcript during Mullins' testimony. And now we're going to hear it. Now we're going to see the interview. And they're doubling down. Wonder how that's going to play. Lieutenant Holeman confirmed he had learned from Melissa Oberg between October 13 and October 26th about her results. And Mr. Baldwin asked if he learned that she had compared an unspent shell to a fired shell. And he said no. Mr. Baldwin asked, did you not send the cartridge, the unspent cartridge, to an independent examiner to review that conclusion? No, of course not. They got what they wanted from Melissa Oberg, and then they proceeded. The statement that Lieutenant Holeman reported Rick made in his car, it doesn't matter. It's all over. We talked about that a little bit because that also was not recorded. It was on October 13th, after Richard Allen left the interview room. However, someone drove him back to his home. And that in-car drive was recorded. They have cameras in the cars. They have cameras in their cars, and they recorded them driving him home, but they did not record him making the statement that Lieutenant Holeman thinks is so damaging. Also, on October 26th, when Mr. Allen was put in handcuffs and taken to jail, that was also recorded. But not the one where he said, it doesn't matter, it's over. Mr. Baldwin asked, did he find Betsy Blair credible? He says, yes, he did. And Mr. Baldwin asked, are you aware that she had described a vehicle that didn't look like Richard Allen's car in a place where Richard Allen's car was supposed to be? Yeah, he's aware of that. So they clarify that Mr. Allen's car, the question is, Mr. Allen's car had to be at the CPS lot at 1:30 for your theory to be correct. And he expresses confusion. We have to explain this. We have to explain what this means, that having a timeline means that the evidence needs to fit your timeline. Got to spell this out a little bit. He's acting very confused. So Mr. Baldwin explains, the theory is that his car was parked at that lot at 1:30. According to Mr. Holeman, I don't know where he parked. And Lieutenant Holeman said, well, there were witnesses who said they saw a car matching the description of his car in that lot. So are we at that lot or not at that lot? Getting confused now. There were people who described cars in that area. Mr. Baldwin asked, who are they? Yeah, because we haven't heard from them in this trial. Who are the people that say there's a 2016 black Ford Focus parked in the CPS lot between 1:30 and 3:30 on February 13th, 2017? Not a single person has testified to that. Who are these people? Lieutenant Holeman says Betsy Blair. Mr. Baldwin points out she described a 1965 Mercury Comet. He asked Lieutenant Holeman if Lieutenant Holeman found Sarah Carbach credible, and he said that he did. Mr. Baldwin asked, were you in the courtroom while she testified? Yeah, he was. Do you still think so? Yeah. Yeah, he does. Don't know if the jury is going to be on the same page as Lieutenant Holeman with that one. Hard to say. Hard to say. But she really did not do herself favors with how she testified. Lieutenant Holeman agreed that Sarah was the only person who saw the guy walking down the street, that nobody else reported a muddy and bloody guy. Mr. Baldwin asked, this is a busy road, isn't it? This 300 North, lots of people use this road back and forth. I mean, we've certainly heard testimony to that effect. We heard about how even Sarah Carbaugh, if we accept her testimony, she kept driving past the lot, the parking lot for the trails, to see how busy it was, and there were always cars there. We heard that there were lots of people out on the trails this day because it was a beautiful, unseasonably warm day. Bree Wilbur told us that Rayleigh Voorhees was saying hi to all of these people that they met on the trail, and that it stood out that this man that they saw down near Freedom Bridge, the reason why it stood out is that unlike everybody else they'd said hi to, he didn't say hi. He didn't react. He didn't respond. So we know there's lots of people out there. It's a busy road, isn't it? Mr. McLeland objects to the foundation. Are you familiar with the traffic patterns of Carroll County? And have you done a traffic survey in Carroll County and done any traffic studies in this area? Your Honor, I object. He's no foundation. There's no foundation for him to have any knowledge of the traffic patterns on 300 County Road North. That's sustained. At this point, Mr. McLeland is also starting to look desperate. He looks like he is swinging for the fences and badly missing. He is putting out airball after airball. Oh, it's getting sustained, but the jury is seeing this happen as if the only way that you can say whether it's a busy road, when you get to have enough expertise to testify about how touching your face means you're lying, but you need a foundation. You can't use basic common sense and what we've heard throughout this case to have an opinion about whether 300 North is a kind of busy road. The jury is seeing all this. The only way you know that is a traffic study. I mean, this looked ridiculous. It really did. It was not a good look. And it's a good point. The jury gets the point. This is a busy road. Somebody who supposedly is covered in blood because they just murdered 2 girls is walking down this busy road in the middle of the day in plain daylight. Okay, number 1, that's pretty ridiculous. And number 2, nobody else saw him. We know the cameras didn't see him. So this is a good point, and it's not a difficult point to get. So the jury is seeing this, and this is not a good look for the state. Mr. Baldwin points out, you saw the traffic patterns from watching the Hoosier, I keep saying that, the Hoosier Harvest Store video. It's such a tongue twister. Nope, that doesn't give him a foundation because it was other people that watched it. Other people watched. He didn't personally watch it with his own eyes. So, no idea. No idea how many cars drive on 300 North. Mr. Baldwin asked how many vehicles were traveling on that Hoosier Harvest Store video? I don't know. He doesn't know. Convenient that he doesn't know. That's opportunistic ignorance, that one. This is the lead investigator. There's a rule that sometimes gets applied when you're talking. It's usually when you're dealing with search warrants. It's not like a hearsay rule. It's just in terms of what police officers can use when they're applying for a search warrant. It's called the fellow officer rule because, yeah, it's not always the same person that's talking to the witness or doing the groundwork that writes the affidavit. So they get to rely on the information that the other officers provide them. A fellow officer rule. It's pretty, it irritates me sometimes, but it makes sense. And so, we're to believe that the lead investigator of this shocking murder that devastated this town didn't really know what the other investigators were doing, what they looked at. Yeah, this is also not a good look because either you're lying or you didn't care enough about this investigation because you should know. You should know. You should care about every single thing that your investigators were doing. You're the top. You're where all of this information gets filtered through. You should know it all. So you're lying that you don't, or you didn't belong in this role because you didn't care to do the job. Mr. Baldwin asked, how tall is the Monon High Bridge? And he said he didn't know. Mr. Baldwin asked, would it be prudent to measure it? Lieutenant Holeman says somebody did. It's somewhere, it's somewhere in the information. He asked if Lieutenant Holeman had been down to the end where the girls were abducted. And he said, yes, he has. And asked if, to get down to the creek, you would have to go down, you'd have to go down to the access road and then to get down to the creek, even further beyond that. At this point, we don't know where he's going because Mr. McLeland again objects to it being beyond the scope, and that is sustained. So we switch gears and we go back to the timeline. Lieutenant Holeman confirms that law enforcement's theory, what they believe is that after Richard Allen left the scene at sometime between 3:30 and 4 o'clock, he never returned to it. And so what we did here is establish some things, some foundational things that I suspect are just they're going to come back. We kind of already have had a hint of what it is. But their theory, he confirms, going down the primrose path, that under their theory, Richard Allen did not take Libby's phone and bring it back. In fact, her phone helped establish the timeline that was used for the probable cause. He pointed out that Richard Allen did not sell his Ford Focus. He did not sell his gun, his clothing. He didn't get rid of anything. So this phone that was used to help establish probable cause, he didn't take that. He didn't get rid of any of the incriminating stuff. And they agreed. Libby's phone line would give a good timeline of the events of the day, and that they believed it would implicate Richard Allen, and they believed that that data is accurate and reliable. This is foundational because what this is saying is that there is something in that data that's going to come out in the defense case that is going to be, at best, not helpful to the state. So the state's concession that this data is accurate and reliable, that's why he's pinning them down to this. So that later on, when they can show that the data does not support the state's theory, they're stuck with it. He points out that Anna Spath and Riley Voorhees were both, this was a group of 4 girls. But Richard Allen said he saw 3 people, 3 girls, 3 people when he was on the trail. At the time, he believed that Libby's phone had shut down on February the 13th, but now he knows that that was wrong. We haven't gotten into the details about why he knows that was wrong, but now he knows. Mr. Baldwin asks if he believes there is only one perpetrator. And he says now he does. Now he believes there's only one. At one point, he thought maybe it was more than one, but he changed his mind because based on his experience, when multiple people are involved with a crime, usually one of them will tell. And he bases that on his experience with drug cases. Mr. Baldwin asks, are you equating what people might do in a drug case, a drug dealing case, with this murder of 2 girls? And Lieutenant Holeman says, absolutely. He absolutely thinks those are the same thing, that an addict who has gotten busted and is eager for his fix and is being told things will go well for him if he gives up his supplier, so he does, and he walks out of that police station, that's the same thing as somebody implicating themselves in a double murder. Absolutely. Those are the same thing, according to Lieutenant Holeman. Okay. Mr. Baldwin asks, you believe that one person in 1 hour got the girls across the creek, got them undressed, got them murdered, got them redressed, got them posed, got the sticks on them, etc., etc. Yes, one person in 1 hour did all of those things. Mr. Baldwin asks, would you agree it would be easier if there were 2 people? Lieutenant Holeman says no. No, I don't think I would agree it would be easier for 2 people to do that. Is that a reasonable denial? That it would be an easier thing for 2 people to accomplish all of these tasks than for 1 person? Are we not to use our brains here? The jury will be instructed that they are not to leave their common sense at the courthouse door. They are more than entitled, and in fact should, bring it into the jury room for deliberations. This is just beginning to reek of somebody who is accustomed to not being questioned, to not being challenged, to their word being the end of it. And so the very prospect that the jury might not just accept what he says and what he thinks and adopt that as their own belief and call it a day and send Mr. Allen off to prison for life, he doesn't seem to know how to cope with that. Because this is not a reasonable denial. This is highly unreasonable. Of course, it would be easier for two people to do it. And that's not a hard concession to make. Yes, it would be easier, but that doesn't mean that that's what's happened. People do hard things all the time. Lieutenant Holeman agreed that he believed Libby was killed at the tree. I believe they're talking about the F tree, some distance from where her body was found. So this is a detail of the theory that is, we are hearing this in trial for the first time. Law enforcement doesn't believe she was killed right where she was and then, you know, came to rest in that location. They believe that at a bare minimum, she was killed some feet away and then moved to where she was found. But there are no drag marks, right? We've seen the photos of the crime scene. We've heard the testimony from the crime scene investigators and the first responders and the people at the search party. From the DNR officer who went back to the scene and found the sticks. According to Lieutenant Holeman, there are drag marks. Yes, there are drag marks. They're hard to see. They are there. But they're not from the tree. There just aren't drag marks from the tree. Mr. Baldwin points out, shouldn't we have heard testimony about these drag marks? Lieutenant Holeman, he doesn't know. I don't know. I don't know if you should or not. Mr. Baldwin points out, wouldn't it be easier? You have one person uses a knife on her at a tree, some distance, moving her to a location, probably have to drag her, whereas two people would be able to pick her up and move her, not leave drag marks. Great point. Yeah, this is a good point. How did one person move her? Two people would be able to do that. Mr. Holeman, he does not agree. He doesn't agree that two people could pick her up and move her and not leave drag marks. Mr. Baldwin asked if they could analyze the height of the person on the bridge. Lieutenant Holeman said that they tried to do that, but the cost to do that was $10,000. What have they spent on this trial that they made a point of getting out there in the press to be reported about the cost to Carroll County of this case? 4 point how many millions? 4 point how many millions? And they want to bring up 10,000 to investigate a pretty important detail, the identity of Bridge Guy, and something that might narrow it down. Well, Lieutenant Holeman says, no, it wasn't. It absolutely wasn't the money. The problem was the accuracy. They could only get it within about 2 inches. I went back and looked at what the description of Bridge Guy was that police released to the public. They released a description of Bridge Guy that said he was between 5'6" and 5'10". A 4-inch discrepancy. And they have a problem with the accuracy of this other method. So they won't spend $10,000 out of the 4 point whatever million to investigate that. At some point, when you're not investigating something, it's because you don't want to know. It's because you don't want to know. This is why I talked about this before. There's a reason why nobody asked these witnesses, the eyewitnesses, the ones who saw who they say is Bridge Guy out on the trails. There's a reason why nobody asked those witnesses. Is Bridge Guy that guy sitting there at the defense table? Because they don't want the answer. The investigators didn't want the answer. They thought they already had their guy, and more information could undermine their case. Mr. Baldwin points out if it was a taller person or something that would work. Right? If it establishes that he's like an unusual height, then it would be worth it. Is essentially what he's saying. We've seen the photo. I mean, it seems unlikely that Bridge Guy is unusually tall, but he certainly doesn't look short. Abby and Libby are both 5'4". Richard Allen, about 5'4". Bridge Guy walking up the bridge behind Abby looks quite a bit bigger. They didn't do that because 10,000 and accuracy. It would be more accurate than their existing description, but not accurate enough to spend $10,000. Mr. Baldwin asks, Richard Allen's a short guy, right? He's a short guy? Jerry Holeman's answer, I don't know how tall he is. Not an expert on shortness. Apparently they never covered that in his training and experience, whether somebody is short or not. You need a foundation. You need an actual measurement, just like you need a traffic study to know about the patterns on County Road 300 North. It's starting to become evident that this witness is just resistant. He's resistant to common sense. A short guy, really? You can't give an opinion on whether he's a short guy. He knew that there was human hair in Abby's hand by October 26th when he did this interview, this interrogation. But he had been told it was a female and probably a family member. He knew that he only needed a swab from Kelsey or a swab from Becky in order to confirm it, but he didn't ask for it to be tested. And his explanation is because they had resources, it would take resources that they wanted to put elsewhere, and they didn't have a female suspect, so they didn't bother. Okay, got this? Got this? This was an important little slip here. They didn't test it because they didn't have the suspect. Is there a problem with the order of those events and how investigations are supposed to go? He has just told us investigating the hair in Abby's hand is not something that they would do to develop a lead, to follow that information to a conclusion. He told us only once they have a suspect. Why? Because they're only looking to confirm what they already believe. He just gave away the game. They didn't test it because they didn't have a female suspect. He concedes there was no DNA of Richard Allen at the crime scene. There was no DNA of the victims in his home or in his car. Mr. Baldwin asks if leaving behind the bloody sticks at the scene was a mistake, and Jerry Holeman says no, it was not a mistake. The sticks had been observed, and the crime scene investigators decided to leave them. Nothing to see here. He did eventually acknowledge that there were mistakes, but it was only on the level of Mr. Baldwin pointing out, at the very least, there are some typos in some of the reports. We heard about that from the computer forensic analysis, that guy, about how he had transposed some of the numbers in his report. He had a few typos, little things he had to correct. That's the level of mistake that Mr. Holeman is willing to accept responsibility for. These other failures, no, it doesn't seem like he's willing to accept any responsibility for that. Where does the buck stop in this town? I gotta wonder. Nobody's to blame for any of the mistakes. Everybody's pointing their finger. Even the judge blaming her clerk, not filing the documents in the CMS. Where's the leadership here? Do they even know what that means? At this point, Mr. Baldwin requested a sidebar. And when he came back, he asked, you were aware of the sticks on the girls, and it's your belief that he was trying to camouflage the bodies. He said he's trying to conceal, but Lieutenant Holeman said he's trying to camouflage the bodies. And so Mr. Baldwin then confirms, you don't believe there was a pattern to how they were placed. You believe they were just random. Has a door been opened here? He says the individual took time to lay 3 sticks on Abby, but he didn't believe that the bodies were posed or positioned. This is a bit strange. He acknowledges they were moved. At least Libby, we just heard him testify to that. Libby was killed at the tree. Not where she was found. But they weren't posed? He acknowledged there were no fingerprints, and he pointed out one of the features of this crime scene that is one of the big standouts to me. It's one of the reasons why there's so many questions about what really happened here, and why it's very difficult for me to believe the state's theory that this is just an opportunistic everyday murder. And that's the fact that Abby's hands were clean, pristine, while Libby's were bloody. But they both suffered the same injuries. We heard the testimony from the medical examiner about the instinct to cover that up, to apply the pressure to try to stop the flow. And we heard from the medical examiner that Libby would have passed into unconsciousness and death much sooner than Abby. But Abby's hands are pristine, while Libby's are bloody. The defense is going somewhere with this. I mean, I know from the pretrial, they're trying to get us towards the Odinism stuff. Their theory is that this was a ritualistic killing, and therefore there is a ritualistic explanation for why Abby is pristine and Libby is not. But I'm just very surprised that these questions were asked, that Judge Gull allowed these questions to be asked, unless somehow the door's been opened. Mr. Baldwin asks if from the crime scene location you would definitely hear people on the bridge. Mr. McLeland objected to that as speculation, and that was sustained. At this point, Mr. Holeman, this is like the first time in quite a while I've seen him look at the jury. Now, in fairness, as you know, I have had my head down, rapidly trying to scribble as much as I can. It is getting very difficult to hear. They are proceeding quickly. I am trying to get as much as I can, so I'm not, popping my eyes up to stare at him all the time, but we're having a very hard time hearing because he's answering the questions about like this now. So you really got to stare and like try to get eyes on him and try to supplement what you're hearing with your ears with what you can, try to lip read. So this is the first time I saw him look over in the direction of the jury in a long time, and he then looked down. And I made that note. Looking down? Sign of deception. Surely the jury sees this. We restated his theory, the law enforcement theory of the case, that Richard Allen heard people on the bridge from the search party, so he killed the girls and then he left. Jerry Holeman says, well, I'm not sure about the order, but I believe he could have heard something. What he means is the order of the hearing something and the killing. This doesn't make any sense at all. What we were told in the opening statement was that Richard Allen wanted to have his way with them, and then he was interrupted, he heard something, and that's why he killed them. Why did he kill them under Mr. Holeman's theory if it's not because he heard something that scared him? We know he didn't have his way with them. Well, I guess we don't know that yet. We'll wait until we get the DNA analyst on the stand, the body fluids analyst, whoever tested all those swabs they took. But we know there was no injury and no sign. And Mr. Baldwin points out the search party wasn't there at 4 o'clock. Search party wasn't there until much later. How could the search party have interrupted him? Mr. Holeman says, well, I'm not sure if I thought it was the search party. I meant the family. And Mr. Baldwin points out nobody got there until 4:30. I thought back about that testimony. That was Derek German's testimony. And so he had gotten to the trails at 3 o'clock and they weren't there, and he waited. They weren't there, so he got out and walked a little bit around and didn't see them. So he went back to his car, and then they started making the calls. It wasn't until much later when he was calling out, going down to the stream, shouting their names. But Mr. Holeman insists there were people there before 3:57, which is the time, the bookend time, when Sarah Carbaugh reports seeing the muddy, bloody man on the road. So he insists there were people there before. Well, yes, that's true. There were people there. There were people there. Not searchers, though. Mr. Baldwin asked, you didn't have any concerns that Betsy Blair provided an inaccurate description of the person she saw? And he said no. Same concerns about Sarah Carbaugh? No. No concerns about them providing an accurate description, even though that description doesn't match Richard Allen. On the video, Lieutenant Holeman, he concedes that he doesn't see who says the words "down the hill." And his belief is that they went down the hill to the right-hand side. So Mr. Baldwin says, you don't know if someone was off to the left. Mr. Holeman, no, I don't think so. I don't think so. Mr. Baldwin asked, did you ever have a discussion about whether there could be two people at the end of the bridge? And he concedes, yes, that had been discussed, but there was nothing to indicate that there was more than one person there. Mr. Baldwin says, do you remember Teresa Wiegert? We haven't heard from Teresa Wiegert yet. Sounds like it may be significant. Jerry Holeman says, yes, he remembers her. And Mr. Baldwin asks, do you know what she saw that day? Jerry Holeman doesn't remember. He doesn't remember what she saw that day. Once again, very convenient, very opportunistic, very self-serving lack of memory here. And not a good look, because if somebody saw something suspicious at the end of the bridge where the girls were abducted, you as the lead investigator, you should know that like the back of your hand. You should know what that is. He doesn't remember because he discarded it because it wasn't useful to the case he was trying to make. Mr. Baldwin asks, isn't it true there was tension between the FBI and the Unified Command? This is a point he is making repeatedly. Mr. McClelland objected to that, and that was sustained. The state really does not want us to get into conflicts in this investigation, where they came from, why they arose, what even really they were. Mr. Baldwin asks him to confirm that the last time Libby's phone connected to the network was at 5:44 on 2/13, February the 13th, 5:44 p.m. Mr. McLeland objects as a foundational question. No foundation. How does he know? Well, Mr. Baldwin points out he said that in his deposition. So we offered the deposition to refresh him. There were a couple times earlier where Mr. Baldwin had offered his deposition to refresh him, and he did the Sarah Carbaugh thing. No, I'm good. He didn't say I'm good. Sarah Carbaugh said, nah, I'm good. You don't need to show me my actual words that confront what I said. I don't want to deal with that. I don't want to have to reconcile this conflict. He said no, wouldn't refresh him to look at his prior testimony. Said that multiple times. This time he did. And so it's there. We had a little bit of one of those courtroom moments that just tells you so much about this case. Mr. Baldwin, to refresh him, you have to hand the document to the witness. Mr. Baldwin asks Mr. McLeland if he minds if he just hands a small part of the deposition because he holds it up. It's very thick. This deposition, there were two depositions apparently that they took of Lieutenant Holeman, one in August of last year and one in I think March of this year, maybe May. And the deposition transcript is like 4 inches thick. Holds it up, we all get to see it. Mr. McLeland then says, well, I don't have a problem with it, but I don't know why you're asking me. The judge runs the courtroom. And Judge Gohl, who, sits there with her imperious pose at the bench for most of the day, looking down her nose, looking through her glasses at everybody, glances over at Mr. Leland and gives him a fond little smile. The judge runs the courtroom. That pleased her to hear him say that. After being refreshed, he confirmed, yes, he did say at his deposition that the last time Libby's phone connected to the network was at 5:44 p.m. on February the 13th. And Mr. Baldwin says you can't rule out that Libby's phone left the area on the 13th and returned in the early hours of the 14th. Mr. Holeman doesn't think that's what happened. He talked to the forensic guys. Doesn't think that's what happened. Mr. Baldwin points out Kelsey German's phone is never analyzed or extracted. This is interesting. This is an interesting angle. This is also a potentially dangerous angle for the defense. So I wonder where they're going here, because extracting Kelsey German's phone, it's a little bit like treating her like a suspect. And we know the hair. We know the hair in Abby's hand. We know they didn't run that down. Probably naturally concluded the sister isn't a suspect. But then you think about it, and is that an assumption investigators should make? Is that an assumption that they should make? It's a very dangerous implication for the defense to suggest maybe you should have treated her like a suspect. So I wonder where they're going to go with that, or if they're going to go anywhere with that. This is a precipice. Mr. Baldwin asks if they should have if they could find something that might be of assistance. And Mr. Holeman said no, he doesn't think that it was an error. Does not think that was a mistake they made to not analyze Kelsey German's phone. Mr. Baldwin gets him to concede that in his conversations, in all of the conversations about what is on the phone, his position is that nothing contradicts his theory that the phone was under Abby the whole time. But they had previous conversations about this, and Mr. Holeman said, they didn't learn until the last few months that the phone had reconnected at 4 o'clock the next day. So that was very recent that they learned that the phone reconnected at 4 o'clock the next day. Mr. Holeman said, I think I knew, I just forgot. This man has no business being a lead investigator if he can't remember. If he can't remember important details like the phone activity that he just already said in his earlier testimony is really important for establishing the timeline, for giving us the events of the day. But he thinks he forgot about it reconnecting the following morning? After all this time, that their view was that when it lost connection to the network at 5:44 p.m., it's because the battery ran out and it turned off? And he just forgot that he knew that that wasn't true because it reconnected the following morning? By the end of this cross-examination, Lieutenant Holeman was not having a good time. I mean, like I said, he's talking like this. He has long since abandoned the Troy McClure turn and flash that grin at the jury. He has long abandoned that. And the few times I'm watching him kind of glance over, he's doing the glance over and look down. He doesn't maintain eye contact with these people. He's not having a good time. This did not go well. This was an absolutely terrible, terrible day for the lead investigator in the murders of Abby and Libby. Terrible day. So Mr. McLeland decided he would have a bad day too. And he got up for his redirect. So he starts by saying, I think Mr. Baldwin has mischaracterized some of the evidence, and I want to clear that up for the jury. So first, the phone video was taken at 2:13, right? Yes. But Sarah Carbaugh saw the bridge guy on the road at about 4 o'clock. So that was closer to 2 hours. Well, we do have to account for the time that it took for Bridge Guy to get from the crime scene to where he was seen by Sarah Carbaugh. But this is a gotcha. Closer to 2 hours, not one. Closer to 2 hours. And the video shows the abduction of the girls. Yes, it does. Mr. Holeman, Lieutenant Holeman, he has also observed the video, and he believes the voice that you hear is Bridge Guy's. He believes that. Based on what we don't know. Just that that's what he believes, because he's decided it's one person. Entertained the possibility before it was two, but nah, couldn't be because of that whole prisoner's dilemma problem. That happens every single time. That's what happens. So if nobody has snitched, can't be a two-man job. It's got to be a solo. Mr. McLeland asked, did you find anything about another male on the bridge that day? No. And Betsy and Sarah both identified the person they saw as Bridge Guy. Yes, we've heard all this. We already know. The jury is already taking this into consideration with everything else. We don't need to hear it for the 20th time. When Mr. Baldwin asked about what Riley Voorhees and Bree Wilbur and the girls on the trail, what they had seen, or I'm sorry, when they asked Richard Allen who he had seen on the trail, he said girls. He didn't say people. Mr. Baldwin, when he asked, the point being, Betsy Blair and the girls themselves said they're 4. Richard Allen said he sees 3. The point is the number, not the gender. But Richard Allen is very misleading. He saw girls, not people. Swinging hard to connect on this one. Didn't land for me. Didn't land for me. This was weak and desperate. Mr. McLeland says, and you think the sticks were there on the girls for camouflage? And he says, yes, but they may have been there for, and I couldn't hear what he said at this point. Lieutenant Holeman is still speaking extremely quietly at this point in time. And so I could not quite hear what he had to say. But I was reading through on Substack. I have been following Dave Bangert. He is one of the guys who is he's one of the press guys. He's a retired journalist from Lafayette. And but he when I first met him, he wasn't able to get credentials because he's retired. So he doesn't have the necessary relationship either. I think since then he's gotten on board with somebody else because he has been able to get press credentials from time to time. So he's been writing about this case on his Substack as well. Oh boy, I had it up and now, okay, here it is. Now we lost it. He heard that word. I didn't hear that word. I was behind Lauren, Hidden True Crime, and her crew. None of them could hear exactly what it was either. So we were all kind of trying to figure out what this word was. It was there for camouflage, but it may have been there for a something. Dave Bangert reports that it could have been the sign of an undoing. The word was undoing. And I think that's part of why it was hard to make out, because he's being extremely quiet and it's a strange word in that context. But it apparently makes sense because this is something that's come out in the course of the pretrial hearings. That the idea of an undoing is this idea that a killer or just any criminal, frankly, may do something to try to express like it's a response to guilt or to remorse for what they have done. And so the examples of that might be things like putting the clothes back on Abby, Trying to undo, like do something symbolic to undo what you did. I really don't know how the sticks would undo anything. The sticks, the girls didn't have sticks on them before. You're not undoing, you're not restoring them symbolically to the way they were before you murdered them by putting sticks on them. So that doesn't make sense to me at all. I feel like this is, I mean, I don't know because I didn't get to attend those hearings. Catastrophe has sent me the transcripts and I can't wait to go through them. It's probably not going to be this weekend, but the transcripts from that big evidentiary hearing. My suspicion is that the undoing is part of a defense theory. If they're saying it's ritualistic, that's ritualistic behavior. That's symbolic behavior. That's not just a crime of opportunity and I get interrupted and so I kill them and I leave, like we were told at opening. So we're all over the place with what this theory is, and it's not consistent. It's not making a lot of sense. This sounds to me like Jerry Holeman just sort of jumped on something that the defense has probably proposed to try to kind of make it his own. I don't know. I found that, couldn't hear it in the first place. When I saw what Dave Bangert is reporting, it made sense. Like, yes, that conforms with like the sounds that I heard that I couldn't quite make sense out of. I heard like Dewey, I heard like Dewey, and I'm going, what on earth is he saying? And undoing. But it doesn't make any sense with their theory of the crime. It may have been an undoing. We revisited a phone connected to the tower at 5:44 p.m. and that was the last time that the phone connected. But there was some information. It was actually pings, had to do with pings to the phone. And Jerry Holeman maybe thought it maybe the phone powered down. So it's like we're drawing a distinction between the phone connecting to the network and the phone being unable to be pinged. Like this is a gotcha. This is Mr. Baldwin mischaracterizing the facts. Like this is petty stuff. This is insignificant stuff that doesn't matter. This is just like expressing things in a way that is simplifying it, because what's significant about it isn't the detail that you're nitpicking. It's the other part. It's the lack of connection. That's what matters. We all know that that's what matters. So trying to turn this into Mr. Baldwin is the bad guy up here and he's lying to you. This didn't work at all. And it makes you look bad. It makes you look bad because now you're making it personal. You're doing an ad hominem here now. You're attacking the guy and you're accusing him. And this is what you're bringing? Very bad look, I thought. Very, very bad look from Mr. Baldwin, or from Mr. McLeland. Mr. Investigator Lieutenant Holeman agrees there's no indication that the girls were taken in a vehicle after the video ended, that they were taken, no indication of that. There's no indication that the killer was going to have his way with them and got interrupted, and that's why he killed them and left. There's no indication the phone moved again after 2:32. And he concludes with, Mr. Baldwin said that one of the lies you told Richard Allen was that other people had seen him on the trail. But we know other people reported seeing him on the trail. Betsy Blair, Rayleigh Voorhees, Bree Wilbur all said they saw him on the trail. That's a big gotcha. Well, the problem with this, as Mr. Baldwin points out when he gets up for his recross, is that you are the one who said that you lied about the people on the trail. I didn't say that. He's absolutely right. He's not the one who said that. He just said, you lied. You lied during this interrogation. And it was Lieutenant Holeman who volunteered. I lied 2 times, once about the witnesses on the trail being able to identify him. That's what he was saying. That's what he lied about. Not that there were people out on the trail that said they saw a guy, but that they could identify specifically Richard Allen as the guy that they saw. So just instantly, that one's gone. No. McClelland, you need to pay attention, because it was Mr. Holeman that volunteered that. And you're up here calling this guy, saying he's trying to mislead the jury? Who just tried to mislead the jury to make your point? This was a bad redirect for Mr. McClelland. He would have done better. He would have done better to just not get up at all. You know, sometimes one of the hard things about being a lawyer, you got to edit. You got to edit, you got to prioritize. There's always a million things in a case, and the problem is if you don't distill it down to what really matters, you run the risk of losing a jury. You just run the risk of losing them because it gets too convoluted and they can't sort it all out, and it sounds too complicated. You have to simplify. And part of that means sometimes knowing when there's nothing to say, when there's no point in saying anything. People get the idea sometimes that I need to do something and redirect just for the sole purpose of getting the last word. Kind of like people sometimes think in cross-examination, I need to ask all kinds of questions just to make it look like I'm really hammering this guy. No. Some of the most high-level, most experienced, successful, skilled attorneys will tell you that often the most effective cross-examination is the shortest one. And I will attest to this. Some of the most powerful cross-examinations I have ever seen have been like one question. When I took trial practice in law school, the guy who taught us was, he was a career public defender from the San Diego County Public Defender's Office. He had been to trial hundreds, if not thousands of times. He had been on, been in high profile cases, been on TV with some of the cases that he'd defended. And his approach that he taught us was that basically, if at all possible, if you can keep your cross-exam to like 5 questions or less, that's the best. That's the most effective. So you need to know when to edit. You need to know when you are being effective, and you need to know, be able to distinguish that from when you're not. When you don't have anything to achieve here, and one, you're just wasting time. The jury has already heard all this. You're not achieving anything by bringing all of this back up. This is not argument. They already know. So you're just wasting part of their Saturday to restate the same things that they have heard a dozen times, if not more. But the other side of it is the risk factor, because every time you open your mouth at trial as a lawyer, there's risk. You are risking. You are risking getting a bad answer. You are risking that you made a mistake. We saw that with Miss Auger. She made a mistake. She objected to the jury being told what investigator Mullen thought was on the video, thought the video said in the enhanced video, the words on it, before they had a chance to hear it. We had literally just finished hearing it, Every time you stand up and open your mouth in court, there's risk that you're wrong, that something is going to go sideways. So you have to take a calculated risk. This did not pay off for Mr. McClelland. He got no benefit He got no benefit from this. And the downside, he looks petty. He looks like he's going after Mr. Baldwin because Mr. Baldwin was effective, exceptionally effective. He made this police officer, this law enforcement officer, made him crumble, took that little shit-eating grin right off his face. And so that's what Mr. McLeland was trying to undermine, was not the evidence, because he didn't have anything new to bring. He was trying to undermine Mr. Baldwin, and it showed. It became very clear. Mr. Baldwin followed up that if Mr. Allen had been out there at an hour or two earlier, he could have seen different girls. Yeah, that's right. If he was actually there in more of the 12 to 1:30 time frame that he said in 2022, and not the 1 or 1:30 to 3 or 3:30 time frame that he gave in 2017, yeah, might have seen some different girls. He asks, is there a way? Oh, wait, I'm sorry. We went to the jury questions. That's all Mr. Baldwin asked. We went to the jury questions at this point. The juror, I saw one of the juror questions come out because as soon as the judge asked, does the jury have any questions, I heard the sound of the paper being torn out of the notebook. This juror was ready, was so ready to get that question out. Gets it out, passes it up. The jury's question. Is there a way to get to where the girls were, or to get to where the girls were? Is there a way for a bridge guy to have gotten to where the girls were without crossing the bridge? I didn't obviously get it verbatim, but that's the gist of what it was. And he answered, possibly from the back way. So yeah, could have gotten to that location at the south side of the bridge, down this road and the access driveway that we've been hearing all about. That seems perfectly possible. That bridge guy could have gotten to the girls from that side. And you know, then that might explain some of these discrepancies, possibly. So Mr. McLeland, they get a chance to follow up. The parties do after the question. Mr. McLeland couldn't let that one go, and maybe he should have, because I don't know that this went where he wanted it to. So he points out on the video, Abby is on the bridge and bridge guy is behind Abby. Yes, that's what we saw. And he would have had to have started at one end of the bridge or the other. Yes, that's basic logic. To get on the bridge, you had to start from one side of the bridge or the other. And we know that Libby is at the south end of the bridge. How do we know that? Because we can see the gravel on the ground in the video. She is standing on the ground at the south side of the bridge. And so according for Mr. McLeland, for bridge guy to get there, common sense tells us that he started at the other side, because otherwise he would have had to pass them and then come back. Common sense tells us that, according to Mr. McLeland. Here's what common sense tells me, and it honestly hadn't really crossed my mind until he brought this up. It honestly really hadn't crossed my mind until he brought this up. That actually, what my common sense tells me is that the reason why you would turn the video on in the first place seems a lot more likely to me that somebody has walked past you and then turned back and is approaching you again, as opposed to Some random person that you've had no interaction with is approaching from the distance. Which one of these situations sounds like it's more likely to creep you out? Ladies out there, some random guy just happens to be walking behind you versus some guy walks past you and then turns around to follow you. Which one of these is more creepy? And which one of these do you think you might be more likely to pull out your phone and try to document? It's going to catch your attention. Some random guy walking on a bridge where lots of people walk. What's especially notable about that? If there hasn't been any prior interaction, and there wouldn't be under Mr. McLeland's common sense theory. He just walked up behind them and that necessitated them filming him? Or maybe he walked past them and turned around. Yeah, that's going to creep people out. It's going to creep me out. Hadn't even really thought of that. And he brought it up. That's common sense to me. I wonder what the jury's going to think. Common sense tells us he had to have come from the other side. Why? That doesn't compute for me. I mean, I don't know if anybody on the jury had the same idea as I did. You know, actually, maybe common sense is the opposite of what you're saying. You've just really put a lot of distance between yourself and the jury, and that's not where you want to be. If you want them to vote for you, that's not where you want to be. You need to be in alignment. You need to be on the same page. You need to be thinking the same way. If anybody on that jury had the idea that I did, yeah, I've lost faith in Mr. McLeland's perspective of what common sense is, because that is not common sense to me. From my personal experience, were I on the jury, that would have been extraordinarily damaging. Extraordinarily damaging. You just introduced a whole idea. Hadn't really thought about it, but I sure have now. Sure have now thought about what makes sense as far as how this crime came together and what explains some of these little pieces. Why nobody saw a bridge guy? None of the descriptions look like this guy on the bridge. Yeah, the video, it's not the clearest. It's not the clearest. But does this look like a tall, muscular man in his 20s or 30s? Does this look like a man who is beautiful in his appearance? Kind of looks like your sort of typical, middle-aged, beer belly, stout, hunter dress kind of guy. Not a tall, muscular young guy like people saw. So where's this guy? I don't know. Maybe he's down there at the south end of the bridge. Mr. Baldwin points out the photo at 2:07 that they've put in of Abby walking down the bridge as Abby is headed to the far end of the bridge. There's nobody behind her then. You can see all the way back to the beginning of the Monon High Bridge Trail. There's nobody behind her then. That's a good point. Mr. Baldwin asked, do you think it's preposterous that somebody would walk past and turn around? I like how he phrased that. Preposterous. Would we be stupid if we thought that? Because if the jury thinks that, you want to go ahead and call him stupid? He knows. He knows. He knows that one. So he gives the answer, maybe. Maybe. Is it preposterous? Well, I don't want to be pinned down. I certainly don't want to say no because I don't want to open that door. I don't want to concede that possibility. But I am self-aware enough to realize people on the jury might entertain that possibility, and I don't want to be calling them stupid. So for me to be able to navigate that pitfall, I'm going to go with maybe. This was a great question by Mr. Baldwin. And another very good point. The man on the video, guys down the hill, he wasn't huffing and puffing, was he? No, he wasn't. You see how far back on that bridge it is to the beginning of the trail? Or the beginning of the bridge behind Abby, and nobody's there? Gonna have to keep up. Right? 12 minutes later, he's caught up with them all the way down on the other end of the bridge. A second jury question was, do you know where Derek German was when he was shouting for the girls? And Lieutenant Holeman answered, he's not sure, but it would have been down by the river. Yeah, where everyone would have heard. Would have been down by the river at some point. I believe Mr. German testified first that he went back out on the trails and he was calling for them. It was only later that he went over to the other side and was looking over on the other side. So, yeah, I'm sure he was down by the river calling out for them at some point, but the testimony had him calling out for them when he went back up on the trails. That was today. That was what we got. That was what horrified me. I don't know if there's really, for those of you that have been on this case from day one, I don't know that there was anything in there that's like new information, shocking information. The way that it came out today was devastating. This was devastating for the state. This just looked absolutely terrible. Absolutely terrible. Between the actual factual information that was elicited, that's like, even on direct examination, this is so bad. He's lying because he touched his face. To the shift. Want to talk about change in demeanor? You want to talk about change in demeanor? Oh, you should have seen Jerry Holeman shift from the beginning to the end of that cross-examination. To Mr. McLeland desperately trying to recover something, anything, and just really making it worse, digging that hole deeper. This was a really, really bad day. Really bad day. Really bad day for the state. Today made it look, once again, Like they just picked the guy and decided they were going to go after him. Their own description, of the things that they were doing make it sound like that. They don't remember stuff that should seem to be critical, important details of the case. If they don't corroborate the state's theory, they don't remember them. They just forget. Losing the stuff that's important, the stuff that matters. Yet another video malfunction. Yet another video malfunction. For a case built on coincidences, you know, I hear that so much. I get it. I really do. That's the nature of a circumstantial case, is that when enough circumstances that are potentially indicative of guilt, enough of them coincide, eventually people say, you know what? Can't be a coincidence. All of these things being true. Awfully coincidental. All this forgetfulness, all of this losing evidence, all of this not investigating certain leads. Awfully coincidental. Cuts both ways, doesn't it? So yeah, I walked out of the courtroom today pretty convinced that the state has a big hole to climb out of if they're going to get a conviction here. A big hole. And their last hope is these confessions. The bullet, the bridge guy, brutal murder of brutal murder of 2 little girls. The bullet, you know, we're going to keep coming back to girls weren't shot. The girls weren't shot. The state needs the bullet to be significant. They need the bullet to be significant because it's their only way to link Richard Allen to the crime until they got those confessions. So the bullet, even if this jury of folks from Indiana who seem to know their way around a firearm really seems to be part of the culture here. Even if this Indiana jury is going to accept, sure, we can match a shell casing from a fired cartridge to an unfired one, that those are the same thing, and that there's nothing wrong. We can definitively say that. Even if the jury is going to accept this methodology. And I walked out of court yesterday feeling like I'm afraid that this made an impression. And I say I'm afraid not because I want a particular outcome in the case, but because I'm aware of how unreliable this technique is. I'm aware of that. And so it would be unfortunate for the jury to put a lot of weight on that in making their decision. I walked out yesterday thinking, ugh, they're probably gonna buy this. They're probably gonna buy this. But you know what? Even if they do, they still gotta believe the bullet is significant. And so that leaves us with the confessions. These better be a gold mine. These better be replete with details. And these details, they better not have been spoon-fed. They better not have come after he's already guessed 20 different things and been wrong. They better have come before Mr. Allen got the discovery, reviewed it with his attorneys, and knew what happened to these girls. These better be a gold mine, or I think the state is in very serious trouble. And if they don't deliver, what they did to Mr. Allen is reprehensible. Taking an innocent man, legally innocent, he's been convicted of no crime, and placing him not only in pretrial detention, not only in pretrial detention in a prison, but in long-term solitary confinement. A practice that a lot of countries around the world would consider a violation of human rights. That it seems our own federal courts consider a violation of the Eighth Amendment, cruel and unusual punishment beyond a certain length. This is absolutely reprehensible. And it doesn't look like we're getting any better evidence to substantiate why they did that to him. Without the confessions, it's a bullet that might not have anything to do with the crimes. It's witnesses who describe somebody who looks nothing like Richard Allen. And it's him volunteering days after the murder that he was out there at the bridge that afternoon. That's the case. And so it becomes clear why those confessions were so important. And having now heard a little bit about the Reid technique and how and why that works to coerce confessions from people, it's a lot harder to believe that that wasn't the intent the whole time. There's nothing you can do to me to get me to tell you I did something I didn't do. They took that as a dare. Getting harder and harder not to see it that way every single day. Oh. I'm ashamed to be part of the justice system on days like today. I'm ashamed of this process for everybody. Let's take some time to go see what you guys think about what we've talked about today. We've got a new member here from Gillian Short One Gill. We got another shorty. Welcome as a YouTube member. Glad to have you part of the crew. Catherine Joy with a super sticker. Really appreciate that, Catherine. Kate Eleanor from across the pond here in the UK. Bollocks. That's right. I tried to keep it cleanish for a little bit, but I'm sorry. I'm still worked up. I am. This is just the stuff that it's so upsetting to me. It undermines. We want to believe in the system, we have to. Or our society will kind of crumble if we don't have ways of administering justice as a community. If we can't rely on the systems we have to administer justice as a community, then things descend into chaos and it creates a vacuum. Today's book recommendation, sometimes, people like the book recommendations. I love to read. I love to read nonfiction. I will recommend fiction. I did the other day. I mentioned Lovely Bones. That was my comment, my literature comment yesterday. Today, the book I would recommend is Ghetto Side by Jill Leovy. It's a little, I don't want to say dated now, but it is a few years old. It's a book about the murder of a police officer's son in South Central Los Angeles. And it follows the investigation of this murder and uses that as an opportunity to view the problems with law enforcement in a lot of these underprivileged communities. A lot of the racial issues that are implicated in that, the historical problems that have led to things being the way that they are, why things are so bad in these areas. And the bottom line is that, sadly, most of these communities have never had a reason to trust law enforcement for justice. Justice was never there for them. It wasn't about them. Their victimization didn't matter. And so when you can't look to the official systems for justice, it creates a vacuum. Somebody else will step in and provide it. And in a lot of these communities, that's the gangs. That's why the culture is the way that it is. A very, very powerful book. Strongly recommend it. I enjoyed it thoroughly. Mike Dorado, I'm sorry our fills are out of it. I am too, but I'm just kind of learning to take it as routine at this point. This is just how it goes for us. But you have knocking this trial out of the park. Stupid pun to say how great you're doing. Thank you, dear. Well, thank you. I appreciate the compliments. I'm glad that I'm able to bring some light to this because, yeah, today is the kind of day where the fact that the public hasn't been able to see this, that's an injustice. This is why courts need to be open. You all needed to see what I saw. This needs to be exposed. This reminds me, I got a gift today, this morning in the line. I was given a Justice for Abby and Libby bracelet by Truth Seeker. Thank you, Truth Seeker. It's awesome. The reason why it reminded me is because it has the quotation on it. May that which was done in darkness be brought to light. Amen. Dr. Tiny Toff, have you seen any reaction from anyone else in the courtroom, in the gallery, or jury to these testimonies, or even to Judge Gold's modus operandi? Or does everyone seem relatively unfazed by it all? You don't necessarily see a lot of it happening in real time. Certainly when we come to recess, there are lots of reactions. I noticed today, a lot of people really worked up like I am. People just disbelief about what we're seeing. For most people, you know, I always recognize I see this case different than lay people do. Because I'm seeing a lot of the legal stuff. I'm seeing it through that lens of I've litigated a lot of this stuff. I've become familiar with this stuff. And so with things like the Reid technique, you know, this is something I'm particularly aware of and sensitive to. If you're not a true crime junkie or a justice junkie or something like that, that may have no significance to you at all. And so why would you react to that? But pretty much everybody understands you coincidentally, you just happen to lose that part of the video that's really important to you establishing the constitutional validity of your interrogation. Everybody understood the significance of that. And so a lot of people I saw that were worked up about that. A lot of people that I've seen that seem to be a little bit more inclined to have already, you know, judged guilt, didn't have a lot to say today. Got kind of quiet. So can't say I'm seeing like, you know, nobody's doing like DUI guy reactions in the courtroom during this. We have decorum. That's not how it's going. But definitely when we get a chance to kind of talk about the perceptions that we have and stuff like that, people are definitely getting a lot of reads on things. And up to this point, I think most of us agree it's been really back and forth. This has been a real tennis match of a trial. One day it feels like the defense has just knocked it out of the park. Next day it feels like the state has just made an insurmountable case. The next day it feels like the state has shot itself in the foot. The next day the defense shoots itself in the foot. It's like there isn't a dominant trend where like one side is consistently getting the advantage. It's real back and forth. So I don't know that today will last. You know, I'm saying today is a really low point for the state. It could be different on Monday. It really could. It's just how these things are gone. But they better have some meat to these confessions. They really better, or it's gonna look real bad. It's gonna look real bad, real frame job like. You had the thing, you had the crime. They went looking for the man. Didn't get what they wanted from the Reid interrogation, so we had to turn the thumb screws a little harder to get what we wanted. It's what it's starting to look like. So they better have gotten something good. You know, these good guys that are playing that game of the ends justify the means. Kirsty, will you be heading back to Moreno's after today? I feel like maybe you need to hit something. I really wish, I would love to, but it might not be until we get to like deliberations, just because at this point the timing, it's not going to work. Moreno's is open Monday to Friday. They were closed. They were closed the weekend that I was also gone. Not that they're open on the weekend, but they were closed that Friday and Saturday because I know they were leaving for tournaments. They had some fighters going. So I don't know that our schedules are going to align for me to be able to make it back there. So I might go for a run instead. I've gotten some good recommendations about some trails and stuff like that to check out. Go for a really hard run. Might do me some good at this point. Catastrophe K8, thank you for being so passionate about this and sticking with it. Well, it's wrong. It's wrong. And I've said before, I said last night, I will say again, at this point, I mean, in general, I don't care if somebody is guilty. You don't treat them in certain ways. The whole point is that we are supposed to be better than the people who do things like this. And so if we don't behave better, then we have lost our moral high ground and we have lost our justification for punishing people, putting them in cages in the first place, because we are now just as bad as they are. So this is, it's a horrible thing. It's a horrible thing that's been done. And today just really brought that home for me. Really brought home for me how bad that was. 2 years ago. 2 years ago today. Shell Erba, I so appreciate your righteous indignation. I think we are all feeling the same way. I pray that the jury is feeling this way. Bree, Saturday evening with Andrea G and Runkle. It'd be cool if we could have you all on the live and Bob and Lee. Not asking for too much, am I? You know, it's so difficult to coordinate things right now just because we're so all over the place. But I absolutely love the idea of like a massive group stream at the end of all of this. We have all had so many different perspectives on this case, and that's part of what I love about just the way things have unfolded with this coverage, because it could be very different. You know, it could be a situation where people are getting territorial, or like we're having to fight over, you know, who's streaming at what time and the conflicts, and we're splitting the audience, and things could get very hostile. I mean, you know, there are just some personalities like that, but that hasn't happened. It really hasn't happened at all. And my perspective has been that the folks who are interested in this case are watching a lot of our perspectives. And that's part of the upside. That's part of the good thing about having all of these different people that you can hear from, is because we do all take something different. I'm not definitive, you know? I strongly encourage you to go listen to Lawyer Lee, go listen to Bob Motta, go listen to Hidden True Crime, go listen to Murder Sheet, go listen to everybody, go listen to everybody's take. It really is the best way to get a rounded perspective and to be able to make up your own mind about it. So I think it would be super cool, you know, to do something like that, to be able to have a group stream and just kind of commiserate about everything that we've gone through in trying to cover this case. Hospice Jess, thank you for the hard work. Can you explain a bit more about the differences between the original BG video where he is tiny and the second one where he is magically abducting the girls? They were so incredibly different that, I mean, it doesn't seem like the same video. It honestly, like, I don't know how you don't have some kind of feeling like, is this real? Has this been manipulated? Is there some kind of like AI predictive thing going on with this video? What you see in the first one is so, like, it's nearly all the ground and it's moving. The phone is moving. It's at the ground. It barely turns up to be able to see Abby at all before it's back down on the ground. And it's pointed away from the bridge, like towards that left hand down side of the bridge. When you see the red shape go by, and then hear the guys down the bridge. Hear Libby saying, "There's no trail here." The enhanced video, you just see so much more of the bridge that you don't see. The bridge and the bridge guy walking up behind, you see for like a couple seconds. And on that first video, it's a flash. It's a flash and it's gone. And it's not like you feel like you can see it for 2 seconds, but it's just at a different angle. You know, which is what I would expect if this video is what they have told me it is, that they just used a stabilizing feature. I've used stabilizing editing. I've never seen one that really functions like this. So it wasn't like in the first video, you saw it come up from the ground to see Abby on the grid, and then maybe it like turned or something, and you could still see Abby on the bridge and bridge guy. No, it's like it went back down. So there is a real discordance between them. They really do, and that's something I've also heard from a lot of other people in the courtroom, is just this impression about how different they are and kind of how hard it is to believe that they're the same thing. So I know someday we'll all be able to see them. They will be public, but I just really wish all of you guys could see what I saw. Because it's odd. It's odd. It looks weird. It doesn't really look right. Gorgeous George. That's a famous boxer, old Gorgeous George. I'm 10 minutes behind, but this is breaking my heart. All of my hopes and faith are pinned on this jury. I can't thank you enough for your service to justice. Yeah, I am saying a lot of prayers for this jury. And I just really hope they are committed. Really hope they are. They're going to apply those principles that they swore to uphold, that they advocated for in jury selection. I am just holding out faith that that's going to happen. Rumor has it, it's becoming very clear how problematic this investigation is, and I hope the jury sees this too. I do too. We are so lucky to have your detailed and thorough coverage of this nightmare of a trial. Thank you. You're very welcome. You're very welcome. Conrad Lawrence, according to Aussie Insider, you don't believe your own point of view and you are only here for the money generated by repeating popular opinion. BS. People are entitled to their opinions about everything, you know. There's plenty of haters out there on the internet, and people will think what they think. I have continued to maintain. I am open. I've been waiting. I've been waiting for the case. I've been waiting for the case to be made. I had the same perspective when I watched the Karen Reid case. I'm waiting for the case to be made. And it's not my fault they're not making it. I didn't do that. I didn't do that. Kelly Jane Gillott. The defense need to get one of the Central Park Five, especially Corey Wise, to be an expert witness on the Reid technique and its effectiveness and truth. Yeah, I do wonder if they're going to. They mentioned, I mean, we already know they're going to bring in a psychologist to talk about the prison conditions and how that can contribute to the false confessions. I wonder if they are, maybe going to bring in the Reid technique in that one. It may not be necessary, if only because Rick Allen stood up to the Reid technique. He beat it. He didn't give them what they're looking for. That's why they had to ratchet it up. The Reid technique didn't work, so they had to turn it up to 11. It's mainly just extremely disheartening to me to see that this technique is, not only still being used in 2022, it's being proudly pronounced in a court of law as the basis for what you did and what you think, and this bullshit about the body language and stuff like that. That's what's really discouraging to me. This is so discredited. That apparently has not reached Carroll County, Indiana. Dawn, I appreciate your tone, sensitivity, and weight given to the many tentacles of this case. To quote the Riddler, Doug Carter, thank you so much for speaking truth. There is a lot to this case. I recognize that. Everybody wants the right thing for these girls. It's about Abby and Libby. That's the whole thing. This whole process is about Abby and Libby. And yet, look what we have to talk about. We have to talk about this shit show of an investigation. We didn't ask for that. That's what they gave us. It shouldn't be like this. Santa's little spatula. Since there's a Supreme Court ruling, would it be legal/constitutional to pass a local or state level law to ban cops from lying to people? Absolutely, it would be legal. The Constitution typically just sets a floor, like a minimum standard of what you can't go beneath. But you can always typically give people more protection. And so the Constitution, the case law isn't saying, Fraser v. Cupp doesn't say police are entitled to lie to citizens. It just says that it doesn't violate the Fourth Amendment if they lie to you in an interrogation and get you to confess. So there's nothing that would prohibit the states from recognizing, this is a really terrible idea for all kinds of reasons. And maybe if we wanted to try to heal some of this divide between the blue line and the rest of us, maybe if we wanted to try to restore some faith in the institution of justice and law enforcement, maybe we should pass a law that cops can't routinely lie to people. Yes, they're absolutely entitled to do that. Danielle Cole with a heart. Heart back to you, girl. Jim Green, I appreciate your extraordinary efforts to cover this case. Is this a reasonable hypothesis? Law enforcement ran out of suspects on a case that should be solved, and Richard Allen was the last man standing and then railroaded him. Absolutely. This makes a lot of sense to me. This makes a lot of sense to me. This case had gotten cold. I mean, it was extremely cold. It's like icy, You're going to frostbite yourself standing too close to this case at this point in 2022. 5 years later. Yeah. They find this one thing and they work to make it fit. And it's just unfortunate. It's unfortunate to see that, yeah, this is how the sausage is made. This is how the sausage is made. Not pretty. Andrea Hart, thank you. You're very welcome. Thank you. Bridget Wainwright, to cross the bridge, you'd have eyes down. Could, yes, you would be absolutely staring at your feet to get across this thing. Could Bridge Guy not even see girls at the end of the bridge go down the hill? Is he close enough to reach them in 40 seconds? It really doesn't look like that was one of the discrepancies that has come up. The fact that when you first see Bridge Guy, it's hard to get a sense of the scale. Mentioned before, it came up in the testimony, the camera lens can really distort the perception of distance in an image. A wide angle lens is going to tend to make things look like they're further away. It's going to give you more depth. A telephoto lens is going to tend to flatten things and make them look closer together. Phones tend to have wide angle lenses on them, and so it's likely that this is distorted to make it look a little bit longer, and you can't really tell. If we were able to see it long enough, like the press was able to go back in and inspect some of this stuff, we might be able to like count the rails, look at the rails. The press said there was approximately 12 rails, or not rails, but ties, 12 railroad ties between Abby and Bridge Guy at the point of the video. They didn't say anything about how many from Abby to the end of the bridge. So it's difficult to estimate. It's difficult to estimate the distances. It really is. It really, from my perspective, it looked like Bridge Guy was about as far from Abby as Abby was from the end of the bridge. So Abby was able to make it to the end of the bridge, but it was pretty quickly after that. And I mean, it looked like she was running, in this blur of the red coming by. It looked like she was running. But Bridge Guy manages to be there, a couple seconds later. Is Bridge Guy running? Well, as Mr. Baldwin pointed out, he isn't huffing and puffing. You don't hear it in his voice. Just a bloke. What do you think was the state's reason for putting Holeman on the stand today instead of the DNA expert? Did something happen on Thursday or Friday that forced this? Yeah, I noticed this too. We were specifically told yesterday, at the end of the day, Judge Gohl was addressing like what was going to happen because Melissa Oberg took like all day, and I think that was not expected. And so Judge Gohl was under the impression that the DNA expert was supposed to testify after that. She brings it up that, it's 4 o'clock, and I don't think we're going to get to your DNA expert today. And Mr. McLeland clarifies, he says, oh, actually the DNA expert is scheduled for tomorrow. So as far as today, they worked that out. So made a point of telling us, to expect the DNA expert tomorrow. And I told all of you guys that on the stream last night. It's going to be the DNA expert. That's what Mr. McLeland told us. And then we show up today and it wasn't. It was this very damaging testimony from Jerry Holeman. And so I don't know if there was just a scheduling issue or something came up or what. But, I do know that historically the Saturdays were slower. Not as many people showed up to court for the Saturday session the first week. And I do know that people found the firearms analyst pretty boring. A lot of people got up and left. We had empty seats in the courtroom by the end of the day because people just weren't interested in sitting through all that. The technical stuff isn't particularly that exciting. If it's not something you really geek out on, then you're not necessarily going to go watch that. So I do have to wonder if this was just we're trying to bury this. Trying to put this out there on the day where it will get the least media coverage, right? Because it's the weekend. You're not going to get the weekly night news update. Maybe not going to have as many people in the courtroom. People are expecting the DNA, you know, anyway, and so that's going to be boring. And just give me the 10,000-foot view. I don't need all the details. Gotta wonder. A to Z, I hope Kathy knows that there are folks who care and see this for what it is, that poor woman. Yeah. Yeah. I do. I feel for the families. I mean, regardless of when people are guilty or innocent, I always feel for the families of the defendant. Because they suffer too, and they get absolutely no sympathy, no recognition, no visibility, nothing. Nobody cares about their pain, you know? Oh, you're just the wife of a guilty guy, of some murderer. But she has absolutely suffered through this, and she didn't do it. She didn't do anything. So I always feel for the families, even in situations where, you know, there's a lot better case than this, that the family member is guilty. R&M Productions. Andrea, I really don't have any questions. I just want to say thank you for everything. Well, you're welcome, and thank you. I really appreciate your support, and I appreciate all the information you've put out there about the case. You helped me get caught up with stuff. I am really, really seeing why so many people have cared so much about this case for so long, and why the lack of visibility, the lack of transparency is so extremely frustrating in light of that, you know, because this absolutely should have eyes on it. Bridget Wainwright, did Abby say, is he down there, before Bridge Guy said, hi, who's he? I didn't hear any of this stuff that Mullen said that he heard. I heard Libby saying, there's no trail here, something like that. All I can really hear is just the sound. And so Mullen testified, he listened to this thing, you know, over and over and over and over and over again, had the headphones on and stuff like that. Like, that's what it took for him, you know, to be able to come up with something. We didn't get that opportunity. So I could hear hardly anything on this video. And the problem is that the jury isn't going to be able to do that either. The jury isn't going to get that opportunity. The judge told us in the pretrial motions, the jury asked to watch one of these videos, or asked to hear like a digital exhibit or something like that. They'll be brought into the courtroom and it will be played one time. They'll get to watch it one time. So I don't know what they're going to be able to hear. I just don't know. The crypto tax lawyer, bouncing back and forth. Tonight is Luke Combs' James Taylor tribute concert for the WNC. I'm from Western North Carolina. We'll definitely be on Rewatch Crew. I share your fury, AB. It's beyond egregious. # free Rick Allen. It's appalling. It really is. It's appalling, and it's so disappointing. So disappointing that this is America in 2024. Theory neutral. Your recounting versus that of popular journalists make this sound like two different trials. This might explain the envy/ad hominem attacks. It might. I mean, it might. You know, the first time the jury the press really got egg on its face over its reporting of a criminal trial was Michael Jackson. The Michael Jackson trial, the press really had a perspective on maybe how they thought it should go. And their reporting just really didn't align with what was going on in the courtroom. And so when the outcome came out and it was not what the press had expected, yeah, they were mad about that. Big mad. I mean, we'll see. We'll see what happens. still a lot of trial to go, and it's still ultimately up to the jury. And there's all kinds of variables when you get a jury involved. So Lori Lee Annie, it is so important for people like you to cover this case. Thank you. Please enjoy Sunday Sleep In. We are calling it Sleep In Sunday. It's a holiday. I fully intend to celebrate it to the fullest. I do have some stuff on the agenda for tomorrow. I'm going to be talking with Peter Tragos, just doing an interview for his podcast. So that won't be live right away, but eventually I'm sure he'll release that. But I'll be working on that tomorrow. And then in the afternoon at 3 o'clock Eastern, I'll be going on with Grizzly True Crime. I'm going to go on her channel to do a recap. So if you want to find me there, that's where I'll be to kind of talk about the week as a whole and how things have unfolded. So I do have those on the agenda. And of course, I have some legal work to do. But those are fairly mellow things. I am looking forward to a Sunday Sleep In very much. Eileen, my tainted innocence. Research shows that people who are being deceptive are more likely to maintain eye contact as they are trying to see if you are buying their story. Well, I believe this. I believe this. I watched Amber Heard eyeball that jury, for days while just talking nonsense. Gaslighting us to our faces. Yeah, I believe that. And just a sense that, like, it's performative. When you lie, there's a disconnect because you know that you're lying, and so you can't be authentic, so you're performing. And just like this sense that if I really look at you in the eye while I'm lying, that's how honest people would be. Like you'll feel my sincerity, from staring at you or something. It's performative. James Cassatelli, who's better, Jackson, Yannetti, or Baldwin? They all have their different skills. They all have very different styles. So it's hard to rank them. I can put Rosie and Yannetti in very similar categories because they have very similar styles. They're both like bulldog style attorneys. They're fairly aggressive. They're fairly sharp. Excellent at cross-examination. I would have a hard time ranking them one against each other. They're both extremely talented. Jackson has a more softer touch, but nowhere near the soft touch that Mr. Baldwin has. Mr. Baldwin has, he's got a skill of connection. He's got a skill of authenticity. He is able to speak in a way that just, you feel that he is sincere. You don't get at any point, at least I haven't gotten at any point, any sort of sense of like, this guy is being shady. And I can't say that necessarily about everybody else on the team. Sometimes people exaggerate a little bit too much. Sometimes people just get out over their skis a little bit. I really haven't gotten that impression from Mr. Baldwin. So I do feel like his particular talent is a little bit more unique and special because there's not a lot of attorneys out there who are really able to connect through their communication like that. Mr. Jackson is highly intelligent and he's quick and he's able to maneuver. He's able to adjust on the fly. He's able to respond to the witness, keep track of all of the evidence and so forth. So he's extremely skilled, but it's a different skill set. It's just a different skill set. Mr. Baldwin just has the ability to ask the question in the way that makes you understand what he means and why he's asking it. So of all of them, I guess I would say the most special and unique skill, I think, is Mr. Baldwin's. Choose hope. Wish Jeff was there to give you a hug. Sending you hugs from Austin. You have a beautiful soul. Well, thank you so much. The nice thing I've said many times about having a true connection is that distance doesn't really matter. But yeah, a hug would be nice. Sandra with a super chat. Thank you so much for that. Love in 2 limes. Thank you for being such a good human. I feel like that's not where the bar should be, honestly. But I do appreciate that, you know. Thank you. Thank you. Pine Rider. Andrea, this is Pure Road Warrior Edward R. Murrow, Pulitzer Prize legal coverage. Thank you. Well, you're very complimentary. I realize I put a lot of myself into what I bring to my analysis. I try to keep the reporting part of it as factual as I can. This part of it is new to me. I'm not used to having to be the source of information. I have always preferred to simply rely on sources that are already out there, and just analyze, you know, what's there. So when the trial is live streamed or the legal document is filed or whatever, I don't have to have that responsibility of communicating to you that it happened, you know? And so I am taking that very seriously. I am doing my best to try to give you the facts, but I am certainly going to share with you what I think about them, because that's really what my channel is all about. And so that's a big part of, you know, how new media is so different from conventional media. Traditional media supposedly is supposed to be all objective and neutral and unbiased and so forth, but the problem is that we kind of know that that's not true. It's just there's just been too much over the last, I don't know, couple decades that have revealed how much of modern media is just it's just about serving a narrative, not just in the facts you choose to report, how you choose to report them, but the stories that you choose to cover in the first place. So I think we do have a little bit more of a recognition that yes, everybody has biases and everybody has perspectives, and it's maybe not so helpful to pretend that we're above all that. To just acknowledge it and just share it. And again, I welcome disagreement. I understand a lot of people see this case differently than I do. I don't take that personally. I don't hate anybody because they disagree with me. I mean, to me, that's just ridiculous. Having differences of opinion in a respectful way is a very healthy thing, and it's very helpful for all of us to be smarter. Marianne, has Rick's daughter been in the courthouse? I don't know, because I don't know what she looks like. So I can't say. There's been a whole variety of people that are there at the defense row. Basically, they have a row in the courtroom. I've seen Kathy there every day. Kathy is there every day. Kathy has had a variety of people that she has brought with her. Yesterday, Rick's mom and dad, I believe, were there. I think I've seen Rick's mom a few times, but I don't know who anybody else is. So I don't know. If somebody knows who they are, they would, you know, be a better person to ask. Jilly Bean, I heart you, not in a creepy way. Thank you. I don't take that creepy at all. I'm all for the platonic affection. Lori Lee Annie, very powerful, Andrea. This stuff gets to me. This is at the heart of why I did what I did, you know, in criminal defense for almost 2 decades. This is the stuff that matters. And so this is like all of my worst nightmares come together in one case. So it matters a lot to me. Debbie W. Delphi has technical issues the same way Canton has butt dials. Indeed it does. Indeed it does. Very well observed, Debbie W. George King with a straight super chat. Thank you so much. Poe Honesty. Did the voir dire for the body language occur in front of the jury? Yes, it did. Any opinion on jury body language? No, I mean, like I said, I don't really draw a lot of conclusions from body language anyway. The main conclusions that I draw from it is you can tell when the jurors are attentive and you can tell when they're not. And so, like jurors leaning forward, there's one particular juror who today I noticed, he's in the back row. And he does sit forward quite a bit. He seems quite attentive to the whole process. And I did notice today, like when we were on the recess, the sidebar before we went to full recess, and Jerry Holeman sitting on the stand, and he kind of glanced around at the jury a little bit to like check in on them and see what they think. And then, you know, maybe he doesn't like what he sees because he looks away, and then he's not looking at the jury at all. And this particular juror is watching him the entire time. So I notice things like that. I just, because I don't believe in pseudoscience, I don't really draw any, strong conclusion from that, other than just he's very interested, he's paying attention. I don't know why. I don't know if it's because he hates this guy or because he's, hoping that the guy is going to be able to turn it around, and he doesn't want to miss it when it happens. I can't draw conclusions like that from it. But you can tell attentiveness and inattentiveness, and today they were engaged. 3, any opinion on goals opinion shifting? Not really. I mean, the fact that Mr. Baldwin was allowed to ask those questions about the sticks and the bodies being posed, that seemed potentially significant. It really did. Because it's hard for me to imagine her allowing that in light of all of the third-party culprit being flatly excluded, and that's directly related. I mean, she has Odinism in the order as the things that can't be mentioned. And okay, yes, I realize this is not Odinism, but this is really cracking the door towards that whole angle. So it's possible. I mean, I have to assume she has eyes. She's an intelligent woman. She's not an idiot. She can see what's happening. I wouldn't want to guess what she's making of it. I really wouldn't. Kathy, your realtor in Jersey, you are a superhero for reporting this. Well, I owe a lot of this to the support of everybody that has rallied, the folks that have obviously joined me here, that are supporting me, the folks that took it upon themselves to organize line sitting for me so that I can get some sleep and be able to come back and bring you these live streams. I am not an island in all of this. My husband, my fantastic mods, all of you people in the chat, this is very much a group undertaking. This is not something that I want to take credit for, be all like me. No, this is all of us have come together to make this happen. And I really appreciate everybody's support in making that a reality. DB, can we get an updated Nick and Goal rating compared to Lally and Bev? They're what, 10 times worse than Lally and Bev? Goal, yes. Goal is Bev on steroids. A whole other level. Nick is hard to compare to Lally because unlike Mr. Lally, Nick is a very skilled attorney. He's a very skilled attorney. He just had a really rough stumble today. Not a good moment for him. But he certainly has his idiosyncrasies like all lawyers do. His big one is the repetition. He really likes to repeat things over and over and over again. We got that out of Lieutenant Holeman's testimony today, just repeatedly. He couldn't explain the bullet. He probably said, I should go through my notes and count how many times he said he couldn't explain why, how the bullet got to the crime scene. It was just over and over and over again. So that's his thing. I find it mildly annoying. I wonder if the jury does, because it's just a time thing. We know. You don't need to tell us for the 8th time. We already know he said that. And of course, Mr. Lally did a lot of that too. But Mr. Lally did it with the pointless things, the shoveling the apron at the fire department. How many times did we need to hear it? How many times did we need to hear about the band at the waterfall? The stuff that didn't matter at all, he didn't repeat. It's just, yeah, they're very different. So I'm still going to say Lally is way worse than McClelland. He's not as good of a lawyer. They both have their gamesmanship, that is a little bit irritating, maybe a little bit shady if you look at things that way. But Mr. McClelland has the advantage of actually being very skilled as an advocate. He might be in many ways the most talented lawyer in the courtroom. He doesn't have quite that connection ability that Mr. Baldwin has, but he does. He's got his own charm. It's just different. It's less of an authentic charm like Mr. Baldwin has, and it's more of a just social, just like a good social skills. He's able to like tell you jokes and kind of just knows how to work a room. He's got more of a political type of charm, and Mr. Baldwin has more of a grandfather that you feel safe with kind of charm. BLT, hi, I'm Troy McClure. You might remember me from such telethons as Out with Gout 88 and Let's Save Tony Orlando's House. I love Troy McClure. That's always been my favorite Simpsons gag. Troy McClure, devastated when we lost Phil Hartman. Absolutely devastated. Yeah. My favorite one was always, you might remember me from such nature films as Earwigs. Ew! I just love that one because, yes, earwigs. Ew! Love Troy McClure. Wanda Rubin, please take care of yourself. We need your excellent coverage. I am doing my absolute best. I don't intend to take myself out of commission, and I am pretty tough, but I also recognize, I don't want to push it. So I am working on getting my sleep and having my free time, taking that self-care time. I will go ahead, however, and take this opportunity to point out that if you would like to help out with any of this, if you happen to be in this general area, we are still trying to arrange line sitting. I'm looking for line sitting. Lawyer Lee is looking for line sitting. Hidden True Crimes looking for line sitting. So we have several groups that have come together. Again, they just kind of came together of their own accord. I wouldn't even have the time to try to organize something like this. So folks out there who care about this coverage have stepped up to make it happen. So I have the link for that in the description of the video. I think it's also the pinned comment on this live stream. So if that is something that you have the ability and the inclination to do, I would absolutely welcome your help so that I am able to make sure that I get my sleep and have the time to eat and all those types of things, so that we can keep this going for the remaining weeks that it's going to take. Lisa Shelton with a super sticker. Thank you so much for that. Starlight Selenite, can you show the interrogation videos here? Well, when and if they ever ultimately get released by the court, yes, I could. You know, she's being tight-fisted with the exhibits for now. We don't even get to walk up into the well to view them with the rest of the media who gets to view them. So we, the peons, are excluded from the public access that has been afforded to the media. But at some point, yes, they are public record. They should be publicly available. She can't keep us from getting them forever. So when I get them, I can. Glenn F., my favorite person covering this, hands down. Thank you for being such an advocate for a fair justice system. Well, my goodness, thank you so much for your support, Glenn. That is a wonderful thing to hear. Justice matters, you know, justice matters. If you believe in community and civilization, you got to have a system of justice. And I still hold the ideal that the American system has the potential to be one of the best systems of justice that has ever existed on this planet so far. So far. And so we have so much promise for it to be better. It's certainly not perfect. There's a lot of room for improvement, and that's a big part of why I do what I do. Because I know that there are other people who care, and that, as I always say, these are our courts. This is where justice is done in our names. This is where we serve on the jury. This is real direct representation in our own government. This is where that happens. And so we need to know what's happening, because people, I'm not the only person that cares about justice. Many of us care about justice. And so when things aren't going the way they need to go, when the courts are producing results that are not just, then we need to be able to fix that. We have the power to fix that, and we have the will to fix that. So that's why it's important to get eyes on these just egregious injustices that still continue to occur in this day and age. Nick Starrow, a bit behind, but if lie detectors are inadmissible in courts, how is it admissible that a cop can say who is lying or not? I mean, I'm having a really hard time comprehending what some of the rules are, the limits of some of these rules in Indiana. Like I said, in my state, this would be misconduct to ask these questions. It would be absolutely impermissible to try to elicit any of this. We had a recent appellate decision. I had saved it, and I happened to just look through it a day or two ago, because I was looking for something else, and I checked to see if that was it, and it wasn't. But it reminded me of this case. And so this was a case where a prosecutor had a law enforcement officer on the stand and elicited the fact that they had taken a report and they had referred the matter on for prosecution. And the prosecutor was asking questions to the effect of, if you had not believed the victim, the complaining witness, would you have not forwarded the report on for prosecution? Oh yeah, what I do, my opinion determines how I handle this report and whether I send it forward or not. So I send it forward. They're clearly like saying, if I send it forward for prosecution, this is me saying I believe what I've been told. So it was not even like explicit. They're not coming out. They're trying to play this indirect game. Indiana, I looked at the case law. Apparently, indirect opinions perfectly fine in Indiana. No problem. As long as you don't come out and explicitly say that witness is lying, seems like it's fine. Not so in my state. Absolutely not so in my state. It also seems like in Indiana, it may be limited to commenting on the witness testimony and not commenting on the credibility of the statements that the witness made outside of court. Also not the case in Washington. It's the jury's decision who is believable and who is not. Other people's opinions are irrelevant. They don't matter. So they don't come into court. We have it also grounded in constitutional principles in Washington. Our case law is very strong on this issue. We say that it's an impairment of the right to a trial by a jury because you're injecting, you're trying to substitute opinions on ultimate issues for the opinion of the jury, who constitutionally has the absolute final say on those types of decisions. So many jurisdictions don't. Some of them that, even don't allow this stuff. It's just based on the rules, because the rules say it's got to be relevant evidence, and this isn't really relevant. Washington's is much, much stronger than that. We have it grounded in the Constitution. But this is an excellent point. I mean, now I got to wonder, do they let in polygraphs in Indiana? Seems like it fits that skilled witness standard. If somebody does a lot of polygraphs, then, it's blowing my mind. But I think that's such a great illustration of how absurd this testimony today was. Keminoke. I understand you're upset about the system, but isn't this a good day for the defense? Why did the state elicit this testimony? It's bad for their case. I agree. I mean, yes, this was a terrible day for the state. It was a very good day for the defense. It's just hard for me to, celebrate this atrocity. It's like when you see something on Twitter that is like, it's like a great black humor joke or something like that. And it's like, you don't like it, but you like it, It was a good day for the truth coming out. That I think is something that we can celebrate because a lot was revealed today. I think a lot was revealed today about what this trial is all about. Sarita Banana, I hope you do a Dateline special on this corrupt real-life American horror story dog and pony show. Thank you, Andrea. Much respect. Well, thank you for that. I believe Dateline producers have been here watching the show. I call it, calling it the show, but they've been watching the trial and all of the collateral stuff, that's been going on with the courthouse and all of that. So I expect there probably will be a Dateline production on it. We will have to see. V. Grave, could jury be taken to the prison cell RA was in for solitary confinement to understand the conditions he faced when making confessions? I love this idea. It almost would never happen though. The prison is going to say no, security issues. We can't accommodate that. We can't take a whole jury into the max, the max wing of the facility and then over into this area. And frankly, I just, I kind of doubt the judge would allow it anyway. I love the idea though. They'll get photographs, they'll get video, but I just got done saying the video can be distorting, not necessarily all that accurate. But it'll hopefully be enough to at least give them, some kind of an impression. But yeah, nothing would beat those jurors being able to go in there and see for themselves what this man endured. Oops. Windy DB, heavily redacted videos incoming. Thank you, Andrea, for everything you're doing and for this place. Yeah, maybe that's the reason why we don't get to see him today, and we only get to see him sometime next week. They're going to have to go through and redact certain things. Not impossible. La Kong Express. Shouldn't the shell have had Alan's DNA or fingerprints on it? Mailboxes, mailboxes, mailboxes. Well, we heard a lot about why they didn't take the sticks, because the sticks are such a poor repository for DNA or fingerprints, whereas what you really need is a smooth, solid surface. You know, maybe like, I don't know, a brass cartridge. This is one of those things where, you know, the absence of evidence is not evidence of absence. You can't say because somebody's fingerprint is not on a thing or their DNA is not on a thing, that means they didn't touch it. You can't draw that conclusion, because not everybody is going to shed DNA. Not everybody is going to leave fingerprints at the same, you know, rate. They're not necessarily going to persist. So you can't say absence of evidence is evidence of absence, but if it's not there, it's just one more thing. All of the things, all of the places where there could be some type of trace evidence to connect Richard Allen to this scene, it's not even on this bullet, you know, that supposedly cycled out of his gun. I'm still waiting for the theory, the defense theory, or the state's theory about why the bullet is there at all. Why is the bullet there at all down at the crime scene? They're trying to say he racked the gun up at the bridge, and, you know, he was using that to intimidate the girls. So he racked the gun to intimidate the girls, so they know he's got a gun. The shell casing would be up there. Or not the casing, but the cartridge, it would be up there. It would be up at the bridge under this theory. What need does he have to rack the gun a second time down there in the forest, down there at the crime scene? Why would he need to rack the gun to cycle the shell? Okay, maybe he needs to control the girls again. Well, he controlled them, yeah, and he killed them. So he can't pick up the shell? Wouldn't occur to him, maybe you should pick up the cartridge? It keeps coming back to this weird combination of, you know, this guy is so intelligent that he planned all these things out, but he's so dumb that he made all of these very obvious mistakes. Like, it's a little hard to reconcile. The guy that was going to so much effort to conceal or camouflage the bodies was walking down a county road in broad daylight, covered in blood. PDF photography. Will they put in the store video of the road? It doesn't seem that they're going to put in the video. They have just put in the screenshots that they took of the cars that they think are material. And those are what's in evidence. I don't know if the defense will put it in. Maybe. The defense is going to have to prioritize, though. You know, they've got limited time. They're going to get limited time, and they're going to have so much that they want to put on. I wouldn't be surprised if the store video doesn't make the cut. If they had unlimited time, sure, you know, get it in, but they don't. RK, long-time lurker, first-time super chatter. Today sounds infuriating. You're a badass, Andrea. Your coverage matters. Well, thank you for that, and welcome to the chat. It really is a great scene. It's a little bit different for me now because when I talk and read my notes and stuff like that, I just can't keep up on the chat. I have a hard enough time not, you know, getting my brain and mouth wires crossed and accidentally calling people Judge Bev and the Idaho State Police and stuff like that. It's just so much, you know, a whole other level if I you know, focus on the chat and kind of get distracted that way. So it's very different than when we have a live stream that we get to watch, and I get to, you know, see a little bit more of what goes on in the chat. And I kind of miss it because we have such a good scene here. We're very, very pro you know, free speech. We're a free speech friendly community here. Be respectful of people is pretty much, you know, pretty much the rule. Debate the idea, not the person. And we welcome everybody. Welcome all ideas. Ideas make us all stronger. So glad that you are part of it now, that you came out of your lurking, and hopefully you stick around and enjoy the chat. Brooke E., it's crazy what a few nights of sleep do for your demeanor while sharing this case for us. I like the well-rested Andrea. Your passion is inspired. Well, it's made a big difference for me too. I can tell you that. It definitely has brought me back to life in more ways than one. Jim, I feel so sad and worried. AWLG are never getting justice, not at the expense of RA, but for a future conviction of the actual perps responsible. Thank you, Andrea. Yeah, I know. I think at this point, given the tunnel vision that we have seen from these officers and their insistence on Richard Allen's the guy, in spite of what seems to be the apparent very, you know, weak case that they have brought here, and their unwillingness to consider other possibilities that seem like potentially reasonable alternatives, like, you know, maybe two people were involved kind of thing. It just doesn't give me any hope that if Richard Allen is acquitted, that they're going to do anything else with it. They're in their tunnel vision. They're stuck there. Everything they have done is focused on confirming that. They're in full-on confirmation bias mode. And so the confirmation bias response to an acquittal is going to be the jury got it wrong. That's just going to be it. The jury got it wrong. Nothing else we can do. No point in us doing more investigations or whatever. We had the guy, but the jury let him go. I'm afraid that's what the outcome is going to be. I would love more than anything else in the world, if he is acquitted, to be wrong about that. I would love to be wrong about that. I invite them to prove me wrong about that. I'll be the first one to say, you know what? I was wrong. Jay Slipchi, you should win an award for this coverage. What must the victims' families be feeling through all this? Very conflicted. I can't imagine this is easy for them. I just can't. Yes, they must be very conflicted, because on the one hand, they must have a lot of faith in law enforcement, a lot of trust in law enforcement, because they have to. That's who they rely on. That's who they're dependent on to bring them justice. And so they don't want to have to think we can't trust them and they let us down. They don't want to think that. It's just hard to look at this case and what's come out and imagine how they could not be feeling that on some level. All of this evidence that you've lost, all of these things that you didn't do. Maybe they have just adopted the tunnel vision too. I just don't know. I just don't know. But there's nothing easy about this process for the families. There's nothing easy about it. And it's so regrettable that knowing that the family, the end of the road, when you decided to charge Richard Allen, the end of the road was the family was going to have to sit here in court and watch all this. And it may be for nothing. I do wonder if they just thought it was never going to get to this point. It would never get to this point. They'd get him to confess. And his lawyer, he'd get a public defender who didn't really care, who'd be like, what am I supposed to do? You confessed. Let's just get you the best deal you can. And he's already a broken man. Plead it out. Never see this day come. I have to think that's what they thought was the most likely outcome. It is in most cases. Overwhelming majority of cases end in plea bargains. The Squid. I'm just going to reiterate that this trial is case in point on why you should never talk to cops. The more I've seen of this trial and what evidence they have, and I'm convinced Richard Allen is innocent. True injustice here. It's so unfortunate that the takeaway from this case is you can't afford to be a good Samaritan. You can't. Look at the risk that you're taking if you try to help police solve a terrible crime. Look what might happen to you. It happened to him. So unfortunate that that's going to be one of the takeaways. Lawn Lumber. Hey, Rob. Oh, I'm so glad you came by. Not sure I've ever seen Andrea this pissed covering any trial in the time I've known her. Now I want to know why. Yeah. It's not good, Rob. It's not good. Nothing good about this one. This one is bad from start to finish. Cindy Ruiz, thank you for your unparalleled notes and coverage of this trial. Your insight is so informational, and I'm grateful to have found your streams. Hope to be blessed with meeting you one day this week at court. Absolutely come and say hi. I will look forward to meeting you. I have really enjoyed getting to meet all of the people that are showing up, all the people that are passionate about this case, including the people that don't agree with me. We've had great conversations, and I've really, really enjoyed it and getting to know everybody and their perspectives. Jim, Andrea, in your opinion, having seen the crime scene photos, how long do you think the crime took to commit? Do you think it seems more than one person? More than one person seems, it's always seemed a little bit implausible to me that it would be only one person. And I'll tell you why. I understand this idea that yes, one person can control two people with a gun. They're going to be afraid if I make a noise or if I run away or something like that, he's going to hurt my best friend. And so that's part of how the control works. But I don't see how you can kill a girl in front of her best friend and that still work. I mean, to the extent your leverage is, you've given it up. You've given it up. So, I mean, and just instinct is going to take over. I see you kill my best friend. I'm out of here. I don't care if you have a gun. You know, I don't, and not because like I'm thinking here rationally, like I just think that's what your instinct is going to be. So it has to be, didn't see it. We also know no signs of a struggle. No way that you see somebody kill your best friend and then you don't fight for your life. It's instinct. This isn't rational, logical stuff. This is instinct. You're going to fight. And that didn't happen. So it seems like that puts us in a scenario where the girls didn't know. They didn't know what happened to each other. And how do you do that with just one person with one gun? No signs of them being bound, you know, no ligatures, nothing like on the wrist or anything like that. No sign of that. How do you do that with just one person? That has always seemed very implausible to me. And I thought that the point that Mr. Baldwin made today was excellent. It was excellent. How did one person move a girl estimated at 200 pounds by himself without leaving any drag marks? 200 pounds is a lot to farmers carry, you know, to pick up from the ground and carry. It's hard to see. It's hard for me to see. NJ Kathy with a super sticker. Thank you so much for that. Really appreciate it. Lori Lee Annie, almost 100K subscribers. So well deserved. Thank you. It's been wild the last couple weeks. I didn't really expect all of this flooding in to happen, but I am extremely grateful that it has. Not because, I didn't start my channel to get a lot of followers or frankly even to like make money or anything like that. I don't want a job. I've said before, I'm very fortunate to be at a point in my life where I don't necessarily have to have like a full-time regular job. I have a little bit more liberty to be able to follow my passions and to just follow things that interest me. And that's really what YouTube has been about for me. That's why, I'm not always here. If you're new to the channel, I'm going to warn you, I kind of come and go a little bit because when this trial is over, I'm not going to be just looking for something to come online to talk about just to talk. I'm going to talk when there's something else important to talk about. So I might be gone for a little bit. And that's just part of how we roll here. So it's not that like I started and I'm like, ooh, counting the numbers or something like that, but it's just, I'm just so grateful that what I'm doing here has been able to be so helpful to so many people. That just the information and the perspective that I have, that so many of you care about that. It's really, it's overwhelming. And I'm just very grateful for that. Beagle Mom 7, if they hadn't kicked out the FBI, they might know what is up with the phone after shutdown at 5:45. Maybe. I am on the edge of my seat to find out what, if anything, we're going to get about the FBI and their involvement. We dealt with the TUI process in Karen Reid. We dealt with the TUI process in Brian Kohberger. This would potentially involve a TUI process. I mean, almost certainly would, because it seems the prosecution doesn't want anything that the FBI did. They don't want the FBI's insights. They don't want the FBI witnesses. They don't want the FBI work product. So it would be the defense that would be pursuing it. They're going to have to go through TUI. They don't have that little loophole that the prosecutors and law enforcement have in those regulations, that basically nothing in the process is supposed to impede the FBI or the feds, the agency, whatever the agency is, from cooperating with law enforcement. So I do wonder about that. If they have done, I mean, I would think they've done the TUI process. I wonder what, if anything, they were able to get out of that, and if we're going to see it at this trial. Truth Seeker, hey girl, Andrea, I made it to the green side, just like the green Abby and Libby bracelet I gave you this morning. Much love. Thank you for getting a picture with me. You're very welcome. I enjoyed meeting you. I really appreciate my bracelet. Show that off again. Thank you so much for that. That was very kind and generous of you. And welcome to the green side. It's a good place to be. Jim, LG's phone seems to have stopped pinging as the search started and started again once the search stopped. Could it be the amount of phones in the area? I don't know. That's a good question. That's a good question. Like they overloaded the tower or something like that. I mean, traffic can cause the signal to be dropped. The phone will try to connect to a different tower, but if there's no other tower, I don't know. It's a good theory. It's possible. Emily, just so grateful you are there as a watchdog. Well, I try to stay alert, doing the best I can. These days, the last couple days, it's been the rage notes that have really kept me alert. Share PDX with a super sticker. Thank you so much for that. And Donna Brack with a super sticker. Thank you as well. Annalise NZ. Thank you. It's hard to listen to, but a reminder, justice needs to be witnessed, especially when there are questions about the integrity of evidence and conduct. Yeah. And we should all be able to witness this. We should all be able to witness this. It shouldn't be closed off to just certain members of the public or certain elect members of the people that make it into the courtroom. This should be something that we all get to see because, you know, justice should be for everybody. It really should be. I'm just, if I come back to, if the state felt confident that they were doing justice in this case, they would shine it. They would shout it to the rooftops. They would shine this case as far and as wide as they possibly could. And so the cover of darkness that they have sought to impose on this case, very suspicious to me. Emily, I worry that a jury would be too scared to acquit. I think about this too. I hope that their distance from Carroll County is going to discourage some of that. The fact that these guys are from Fort Wayne, it's, you know, good couple hours away. It's a much larger community, couple, you know, 250,000 people or so. I mean, I think maybe more. That's what she was saying they had on their jury list. So much bigger city, different culture, not so much maybe this small town, old boy law enforcement style of doing things. And that might give them the space that they need to be able to not be, you know, concerned about having to watch their backs, or what are my neighbors going to think, or is this guy going to pull me over next week, and who knows what else they could suffer. Jojo, thank you, Andrea, for being one of the good guys. Maybe trade in that basic good guy hat for a real fancy cape. I do love a good cape. Who doesn't love a good cape? I love a cape. A nice little capelet, like with your dress, is fabulous. Just Jen with a super chat. Thank you so much for that. It's me. There was a murder of a toddler by someone who is not in jail for murder because another man had confessed after the Reid technique. Rip Kaylee Ann Poulton. There have been a lot of instances of just the Reid technique gone awry and producing very unjust results. Somebody earlier mentioned the West Memphis 3. West Memphis 3 is a great example. They leaned on Jason Baldwin, a juvenile who has some cognitive deficiencies. Got him to confess, implicate his friends, and led to them being imprisoned and potentially losing their lives. They could have lost their lives over this. Damien Echols, anyway, could have lost his life. Pam, thank you. You're amazing. Thank you. You're amazing too. You guys are all amazing. All of the support, the rallying around, it's been really phenomenal to see. Anita Gendler, you're amazing. Andrea, thank you for your hard work bringing us updates on this case. XOXO. Well, it's really been my pleasure and honor to be able to bring these to you. Lauren Boren, I'm a 3L writing law review article about overrepresentation of people with cognitive disabilities in prison. What a great subject. I've never heard of the Reid technique. I'm outraged and changing some of the article to cover this. Thank you for reporting. Oh, girl, you are going to go down a rabbit hole. So it's Reid technique, REID. Tons of resources out there about the horror show that this thing is. And yes, very specifically with respect to juveniles, those with mental illness, those with cognitive disabilities, particularly susceptible to producing false confessions. People who are suggestive, people who are especially compliant. Not everybody, I'm very interested in kind of personality types and just characteristics and things like that. The way that we're all different from each other in these very fundamental ways. And some people are highly agreeable, like to the point that they have a hard time disagreeing. Somebody's yelling at you, I know you fucking did it. To one of those people? It's going to be hard. It's not in their nature. That's not how they're wired to be able to stand up to that. Yeah, Reid technique is very appalling. There's nothing new about it. And so the fact that they are flaunting that in a courtroom in Indiana in 2024, they should be ashamed. Christy, a painter's daughter, bless you and thank you. Love that your coverage is so complete. Well, I do take a lot of notes. Since I got them, might as well share them. And I'm really glad that everybody is enjoying that. Just Jen with a super chat. Thank you so much. Catherine Joy with a super sticker. Really appreciate you. Really appreciate your support. Precocent, BG Video, LE Family Interviews, and B McDonald have all previously said the video was 2 minutes and some seconds, beginning to question what has been done to the video. Thank you, and please be careful. That's interesting. I had not heard that. I hadn't heard that. The unedited video that we saw in court, I remember when we watched it, it didn't seem like it was 43 minutes. It seemed shorter. It seemed more like it was 30 plus. It's hard to say. Obviously, I wasn't watching my watch, and you know, a guesstimate's a guesstimate. But the only reason I say that, let's go ahead and throw out my special witness credentials, is because I'm used to the boxing gym timer. And you start to get a pretty good sense. You have your typical 3-minute round and then your 1-minute rest. And so you just start to get a sense of kind of where you're at in that process. For me, like if I spar like a hard round, it's very exhausting, very high intensity exercise. And so the minute, you know, you need a whole minute, definitely need a whole minute to rest. You could certainly take more, but the minute is what you get. And so for me, it's generally about the first 30 seconds that I'm really, and it's only after that, okay, I've started to get my breath back under control and can do my, you know, deep breathe, and I'm kind of back to having a normal, you know, yes, elevated for exercise, but just, you know, comfortable aerobic, you know, level of exertion. And so that's kind of where I feel like I have a sort of good sense of 30 seconds. You know, I could be off. But it did. It seemed shorter than that. MCM11, do you think the jury can be convinced beyond a reasonable doubt based on the evidence so far? Here's the thing. I certainly couldn't be convinced beyond a reasonable doubt by the evidence so far. It's just that juries are extremely unpredictable. And what is convincing to some jurors is, you know, not going to be convincing to others. But yes, I've seen juries convict on very weak evidence. It happens. And so there's always the risk that, yeah, they're going to think, well, these are just too many coincidences. He put himself there at the time and his bullet is there and it's his bullet. And then he comes out and confesses and people saw him there and he backed in his car and he touched his face. I mean, you know, the things add up. And so, yeah, everybody does see that a little bit differently. And the problem is, yeah, there's circumstances that warrant suspicion. I think that that's fair. I think that that's fair. I think the problem is that there are probably circumstances that warrant suspicion of a lot of people. I mean, certainly from what I saw from the pretrial motions, a lot of reasons to be suspicious of some other people. So the jury isn't hearing all that. And when it comes to the beyond a reasonable doubt standard, everybody's going to have a different boundary for where that's crossed, you know? Some people, it's going to need to be close to near certainty. For other people's, once I've decided, that looks bad, like that's it. So you really don't know what you're going to get from the jury. Now, having said that, I did feel pretty good about this jury when they selected it. I felt good about a lot of the things that they said. I didn't love everybody who ended up on it for a whole variety of reasons. But generally, as a whole, I do. I'm positive on this jury. I'm hopeful. I really am. I'm hopeful. These are people that are well-intentioned. These are people that are not going to just sit and have the wool pulled over their eyes. These are people that have been very curious and very engaged in the process. They seem like they want to know. And so these things do give me hope that, yeah, the jury's maybe going to see it my way. I hope. But I just don't know. You really never know. What do you think Libby and Abby's parents think at this point in the trial? What do you think Libby, same thing. I don't know. I really don't. I will tell you a story. Today when we were waiting in line to get into the courtroom, Becky Patty was there early and she gave banana bread to everybody in the line. She was saying that, there was a store or some place that had a bunch of bananas, that they were going to throw out. They'd gone too brown, gone soft, whatever. So they were going to just throw them out. I think it was a grocery. And so she went ahead and was like, well, let's just make banana bread. So she made banana bread. Banana nut bread has pecans in it, and shared that with everybody in the line. And I thought that was an extremely gracious thing to do, because I imagine that, much like the trial, I imagine she probably has a whole lot of mixed feelings about all of the attention. I imagine she has an awful lot of mixed feelings about that. And so I thought that it was just a very kind and classy and generous thing for her to do. Bowie Girl, do you think the defense did their own height and voice analysis based on the BG image and voice? Thank you for all you do. Well, if they could come up with 10,000, and at this point, not sure they could, not sure that they could. I don't know that they would get approval for that funding from the judge. Talked about that last night, and just the problems with expert funding, and especially the conflicts that kind of inhere in that. When you have a judge that oversees the costs for the defense. I know that because of that, they were doing a fundraiser. They were trying to independently raise funds to be able to help them get experts. So I don't know. It's just another situation where they're going to have had to prioritize. We know they were able to get a psychologist. Pretty sure they were able to get a cell phone, a digital forensics. We know that they got the ballistics, the Dr. Waller. So I don't know. Experts get real spendy real fast. And I just don't know that they had a whole lot of a war chest to work with, but I sure hope they did. I mean, it seems like one of those things that could be a game changer. It could be a game changer. Even if the range is within, 2 to 4 inches or whatever. If they're like, yeah, he's 5'8". That's making it real hard for that to look much like Richard Allen. So seems like from a cost benefit, like a risk analysis standpoint, seems like that one might be a pretty good risk. So I would like to see it if they did. Courtney Welch is a new member. Thank you so much for joining. Welcome to the crew. The Piccolo Pesce with a super sticker. Thank you so much for that. John Doe, could you see BG's face in the enhanced video? Not any better than you could see it in that screenshot. The screenshot is actually from the enhanced video. That's as good as it got. That's as good as it got. So you just have little hints of it. Nothing that's real clear and would enable a very good identification. K123 Candy is a YouTube member now. Thanks so much for joining us. CBC Florida court reporter. Academy Award winning Murder on a Sunday Morning with False Confessions, Even Written, Mistaken ID with a Not Guilty Verdict should be chilling. State of Florida versus Brenton Butler on YouTube. I'm going to write that down so that I can check that out. State of Florida versus Brenton Butler. Yeah, you can go along. There's a big rabbit hole of, wrongful convictions. Fortunately, this one was not that. Fortunately, he got the acquittal. But this is pervasive. This is pervasive. It's happened so much. I want to think it is happening less, that we are learning that as time goes by, there's correction and things improve. But that doesn't do a lot of good for the people that were victimized by this kind of thing decades ago. There's not really an avenue for post-conviction relief at this point for stuff like this without more to work with. Like just then this in and of its own right, probably not going to get you a new trial. So Lily, thank you for your very informative and educational videos. I spent all day watching your older videos. I feel like I'm learning so much. Well, thank you so much for that. That's very validating. I appreciate that vote of confidence and appreciation of my work. I will always suggest people want a sample of what I like. The Isaac Bruce series, man, is the favorite thing I ever did. I really would love to do more stuff like that. It was just so fun. Really had a great time doing it. Tony Elia, it's all about having enough doubt. Will there be enough doubt when the jury starts their deliberation? That's the $1 million question. That's the $1 million question. There's still a lot of trial to go. Still a lot of trial to go. We got to hear these confessions. And then we're going to see the defense. We don't even know what the defense is bringing. And they're dropping these little seeds. They're planting these little seeds that are foreshadowing what seems like it's coming. But we just don't know. We got to wait. He told us we have to wait, so we have to wait. St. Simon Trent, as a Hoosier, God bless you. This trial has greatly affected a lot of us, and we are grateful to have a detailed breakdown of what is going on every day. Well, I'm very glad that those of you that are here in the community that this matters to the most, that you're finding what I'm doing here helpful. I admit I have some ambivalence about, being, the carpetbagger or whatever. Like it's not my community. It didn't affect me personally. So why am I here taking up a seat in the courtroom? Well, because of you guys. You guys care about my reports and about my being able to see it and communicate to you what is going on in there. So that really does a lot for me. Just really, really boosts me up and supports me. So thank you for that. Poe Honesty, why do you think the jury asked about Derek German's location? To try to figure out if he is who witnesses saw, maybe? I don't think it was that. Derek German, he's very distinctive in his appearance. He's very large. He's got very red hair. I think that he would have stood out as somebody who would have been like, he's far more distinctive in his appearance than Richard Allen is. Richard Allen, the only thing really that's distinctive about him is he's small, he's short. That's really it. I think it just had to do more with trying to reconcile the state's theory of the interruption? And was it possible that he was the source of the interruption that that would have then precipitated the murders and the flight? That was the read that I got on it. Maybe if he was the source of like some of the footprints or the marks, maybe they're thinking along those lines as well. But I really think it was it had to do with the theory of the interruption. Crispopotamus. I think this case is the last push I needed to finally apply to law school. Thank you so much for everything that you're doing. Well, it is, it certainly, it's not always, but it certainly can be a noble profession. I really enjoyed law school myself. I'm a lifelong learner. I love to learn things. I like to learn different things. I found law school to just be so eye-opening. They say that law school changes how you think, and you know, they don't necessarily mean that in a complimentary way. And it did for me. It absolutely changed the way that I think, but I don't think it's a negative. I think it really just brought my attention to this whole invisible part of the world that I never knew existed. I remember this moment, my 1L year, where it just hit me. It just hit me how much law. I look around and I can see the law in everything. Like I can look straight up at my camera here. I can look at this camera lens. I can see the trade secret law behind it. I can see the law that went into the taxes that the manufacturer had to pay, the employment protections that they had to give to their employees who manufactured it, the import restrictions. I mean, the law is everywhere. And I don't think I had any real appreciation of that, at least nowhere near on the scale that I did after I went to law school. So it did. It made me realize how pervasive it is and how much it touches. So I found it very helpful, and I really enjoyed that experience. So I hope you do as well. Patty Bynum is now a YouTube member. Welcome and thank you for joining. Star Craze, does the jury have to sit through the defense if they are decided not guilty after DT, I think the state, after the state's rests? Yes, they do. They have to sit through it. They are specifically instructed not to make up their minds until they are in deliberations, until they've heard all of the evidence and they're in their deliberations. So as a practical matter, they may be sitting there already knowing what they're going to do. The fact that they're allowed to discuss it as a group outside of deliberations, like already, seems like it's going to help them. It just would logically get them to a point where they're pre-deliberating, like they're coming closer and closer to their perspectives over the course of this trial. So as we get closer to the conclusion, you know, yeah, they might be sitting there with more of an idea of what's already going to happen. But yes, they do have to sit through all of it until the end. And that's a challenging position for the defense. You know, I don't think the jury will hold it against them if the defense puts on more than the jury needs, because the defense doesn't know what the jury needs. They're not mind readers. So they have a duty to their client to make sure that they're putting on the best possible case they can. And so even if the jury has made up their mind and doesn't really need to hear all this and maybe would prefer to go into deliberations and just get it done, I don't think they would hold that against them. Courtney Welch, was RA diagnosed? Will defense introduce RA's experience while in solitary confinement? Free all wrongly convicted Robert Robertson. I believe that he was diagnosed with depression and possibly anxiety. I know that this came up in those pretrial hearings. Dr. Walla, who is different from Dr. Waller. Dr. Waller is the defense expert on the firearm comparison. Dr. Walla is the clinical psychologist from the institution, the prison where Richard Allen was held. And so she's testified at those pretrial hearings. I would presume that if there is a diagnosis, and I seem to recall that there was, that yes, she is on the witness list. She is expected to be called. And yes, they have certainly indicated that we are going to see for ourselves the conditions of Richard Allen's confinement. It's on video. It's on video. And so Mr. Baldwin told us, yeah, we're going to see it with our own eyes. Oh, Susanna, did anyone check to see if Barney Fife lost that one bullet from his pocket? Yeah, nobody seems to be that interested in questioning the Barney Fifes over here in Carroll County. Eliza Joyner, I'm a public history preservation student and worry about the loss of info beyond documents. Your coverage has provided great insight to public responses. Well, good. I'm very glad to hear that. I also worry about that. The transition of everything, so much of our knowledge base into the digital format is such a high risk thing to do. Diversification is the key to risk management. You know, the more sources of information, the more different formats you can have it in, media and so forth, the less likely that something like, oh, I don't know, a solar event that has electromagnetic consequences that affect electronics on the earth, you know, something like that has the potential to be potentially, quite devastating. And if we're at a point where we don't have books anymore because we put it all online and rely on Google to find it for us, it's going to be real tough to recreate a lot of that. So I share a lot of that. I share a lot of that concern. Rochelle D, we need a serious, not too long documentary on all of the questionable things in this case that can be played everywhere. Half the battle is awareness. Yeah, I agree with that. Just getting attention to it is critical. And part of that is getting it out in the public eye, getting the transparency that it so badly needs, and that for whatever reason, the people that are running the show here are so resistant to. For crying out loud, what about the guy who asked if he'd get in trouble if his DNA was found on the girls, if he could explain how it got there? How was he excluded? Yeah, Elvis Fields. I think they said, I don't remember how Elvis Fields got excluded. Brad Holder had an alibi. Yeah, I'm not sure. I'm trying to remember. I think, I think the story was that he and some other folks were visiting a guy at a hospital that day. And as far as I recall, that was just sort of accepted. I don't recall that there was like a big verification process for that. It was just like more than one of them said, yeah, that's where we went. We were at the hospital in Muncie, I think. That cleared him. So his explanation is good. His explanation is good. Richard Allen's is not. Rochelle D, they placed Bridge Guy directly behind Abby in the stabilized video and panned the ground, which makes it possible to calculate exact height with the tech available. Did he look taller than Abby? Yes, he did. Yes, he did. He looked quite a bit taller than Abby. Again, it's hard to tell because of the scale and the perspective. But yes, he looked significantly larger than Abby. If I were going to throw out a rough guess from the video, no less than 5'8". That's what he looked like to me. Jessica Pinky Mingo. So the FBI cannot step in, correct? They must be invited. Thank you for your coverage. As far as the investigation of a local crime like a murder that doesn't have a federal jurisdictional link to it, yes, they pretty much have to be invited into the investigation in order to participate. They can take it over if there is some reason or some aspect of it that would allow federal jurisdiction to be invoked. Murder typically in and of itself is not. There's specific types of murder that qualify for federal jurisdiction, but they're very specific. They're things like a murder that's committed in the course of a bank robbery, a murder of a witness in a trial, a murder of a judge, things like that. And so if those things don't apply, if they did apply, then the feds have the authority to step in and do their own independent investigation. May not necessarily be able to like compel. That's interesting. I don't know if they can compel the state law enforcement to cooperate if the state law enforcement doesn't want to, but I would think they can. You know, they have subpoena power and grand jury power and all of that kind of thing. So I think that they potentially could do that, but they would need that federal hook to enable them to do that. Sentient dreamer, your deep values of respect and dignity are wonderful. Thank you. Again, this should not be where the bar is at. You know, it really shouldn't, but I do appreciate that. I feel like there's nothing extraordinary about that, but maybe I'm just fortunate to be surrounded by people that I feel share those types of things and make that normal, you know. Artemis, seems odd how close to the bridge they were found. Such a horrible and brutal crime where you'd think the girls would have tried to call for help. Another reason to believe intimidation. Yeah, they weren't very far. They really weren't very far. As far as like a hiding spot, it just, I mean, yes, it's remote-ish. It's just we hear so much about people out here in these woods. The fishing, the mushroom hunting, the target shooting, the deer stands. We're like in deer season, you know. February is past, I guess, past that. But still, you know, people scope out those kinds of areas. Not just because like we're hunting right now, but you know, you hunt out where, you know, you scope out where you might want to hunt, you know, next season, stuff like that. It just seems like such a high risk place. Like there's a possibility of discovery, possibility of noise and you know, being heard. So close if the girls were able to get away to be able to get back to where they could alert somebody. Does seem strange that you wouldn't take them a little bit further. Daylily Wellness. Who is Teresa Wiegert? Do you know? Thanks. So I had to look into this. Sleuthy Goosey helped me out with this one. I remembered the name, but I just couldn't place the details and where I had heard of it. Teresa Wiegert lived right across the bridge. She lived right at the foot of the bridge, and she had reported seeing somebody at 8:30 in the morning in that area who was acting strange, and she provided a sketch. So that information was included with some of the third-party culprit pleadings that were done in the case. Yeah. Teresa Wiegert is the one who saw somebody suspicious at the south end of the bridge. That's why Mr. Baldwin brought that up when they were talking about any reason to believe another person, there was a second person, any reason to believe this might have originated from that south end. That's what they're getting at. That's what Teresa Wiegert reported. Artemis. But the question is, if it wasn't RA, who was it? What was the motive? Motive is huge. I would love to know motive. I really would. What's Richard Allen's motive? I mean, I guess they're saying his motive is SA. His motive is to rape the girls. You know, out of the blue, without any kind of apparent history of anything like that. I mean, I guess, can't say it's impossible. It just doesn't seem that likely that you go from 0 to that sort of spontaneously in your 40s. 40s is typically when violent crimes tend to fall off in men. There's a very strong like curve when it comes to propensity. Like I'm saying propensity, it's not really the right word. When it comes to just the tendency to commit violent crime, very much skews youthful. People age out of crime. They age out of violent crime And this is something that is pretty well understood. Obviously, not every single individual does, but as a trend, the older you get, the less likely you are to commit a violent crime. I forget, there is like a cutoff point where, like, after that point, it's extremely uncommon. Even if you have committed violent crime in the past, it's extremely uncommon to commit violent crime in the future. And it makes sense. I mean, at least if you associate testosterone with aggressiveness, which may or may not be fair. There's like a whole lot we don't know about testosterone and how it works and stuff like that. But if that were the case, if that's kind of the correlation there, then it would make sense. Yeah, as men get older, testosterone drops off. They're going to have less aggressiveness, and that's going to make them less inclined to commit violent crime. I say men because by and large, overwhelmingly, men, statistically speaking, commit the overwhelming majority of violent crime. Certainly not the case that women can't commit violent crime. Of course they can, and they do, but just at a much lower rate typically than men do. So I don't know. I don't know what the motive is. I really don't. I don't know what the motive is for any of this. I don't have a clear enough understanding of what happened to be able to understand what the motive is. If it's ritual, like the defense says, I mean, I guess that's the motive. But, why, how, why them? I don't know. I really don't know. Truth Seeker, we have petitions out to order her to air this. I've posted them on a lot of channels too, but this should be air for all to see. This evil, she said no. Yeah, she doesn't want the visibility on it. One of the things that we've all noticed in the courtroom, this courtroom, like just about every courtroom in America today, post-COVID, is video equipped. They're all equipped for remote court now. Because it was a substantial length of time where, we couldn't have people in the close quarters of a courtroom to conduct operations, but you've got people in jail, you've got, processes that need to continue. So just about everybody is video equipped. So in the Carroll County Circuit Courthouse, they have 6 cameras in the courtroom. And they have all been carefully covered with little black plastic bags. They've all been wrapped up. And we learned that that's because the video and the sound system are connected. So the system they use for audio recording to be able to create their record that they're required to keep, they need that, but they can't disconnect it from the video. So they just put the black plastic on it. They actually went to the effort to make it inaccessible. Would have been so easy, but yeah. Law and Lumber. How does one person get 200 pounds floor to shoulder solo, especially a dead weight 200 pounds? Do people understand how 200 pounds, how hard 200 pounds is to lift from the ground? Well, I do. I definitely do. I've never been like much of a power lifter. I've done some, but I never like got super far with that. I think I maxed out my deadlift at like 175 or something like that. Nothing impressive at all. It's heavy. It's a lot of weight just to get it off the ground. That's before you're even talking about getting it into a position where you can actually move it without dragging it. It's a lot of weight. That's a lot of weight to be able to carry off the ground by a single person. I wonder if anybody, I'm going to have to eyeball the jury. I don't recall any of them looking like they have spent much time in the weight room, but I don't want to draw too many assumptions. People have long life stories, and we all change and our bodies change and things like that. So I do wonder if the jury is going to be thinking about that. K-Dog 8173, prayers for the families involved, all of them, 100%. Artemis, would it help RA or not if he took the stand? This is the $1 million question. It really is. The legal answer is it depends. you know, because it depends on how well he'll present. And so the attorneys are going to have thoughts about that. They're going to make recommendations to him. Ultimately, it's his decision whether he testifies or not. He gets to make that choice. That said, most of the time, if you're not dealing with one of the Darrell Brooks types clients who are going to do what they want regardless of what you say, most of the time they're going to respect your opinion. They're going to think, you know, you do this. I'm not the person who does the trials. You've done the trials. You're in a better position to know than me, so I'll follow your recommendation. I have said time after time that my personal position is not the common wisdom. The common wisdom is you don't put your witness on the stand. My perspective has always been, if at all possible, I want my client to testify. And the reason why is because the jury just wants to know who they are. They just want to be able to get a read on who this person is. They've sat there and they've watched them in court the whole time. They've heard all these people talk about them and give them perspectives, give them opinions about who this person is, little bits and pieces of information, and they just want to be able to get their own read. No, they're going to be instructed that they can't hold it against him if he chooses not to. They can't draw any adverse inference from that. But it's natural. It's natural and it's human to want to see that. So when at all possible, I want my client to testify, especially if my client's innocent. If my client's innocent and they're not like so terrible, you know, they're not just an awful person that's going to be so unlikable that, you know, it could potentially backfire. Yeah, I want that client to testify. And I've had good luck with that. My view is that it works. Juries, I believe, can be extremely forgiving of a lot of the things that people sometimes worry about as a reason not to call their client. Well, he's gonna stumble, or he's not very articulate, or he's got all these convictions in his past that are gonna come out and stuff like that. I believe juries can be very forgiving of that type of thing, and really do want to do their best to judge the person and the specific allegation on its own merits. They don't necessarily appreciate the, you know, character assassination type of approach to trying to break somebody down. But it is risky. It is risky, and in this particular case, I've said, Mr. McClelland, he's a skilled attorney. He's a skilled attorney. He would be very skilled at the cross-examination, I think. And so it's a big risk that you take. They have the advantage in this situation of having him on video. I think especially the fact that now we are going to get to see these interrogation videos. We're going to be able to see kind of his baseline, where he was before we hear all of these confessions that we're expecting to hear. So we're going to be able to get to see a lot of sides of Richard Allen without having to put him on the stand. So you don't have that in a lot of cases. And I think that does give them a little bit more freedom here to maybe not feel so constrained. But, you know, the jury, I think, is gonna maybe want to know some things. They would love to hear from him. Why did you change the times that you were there? You know, did you just not remember? Why did you think 1:30 to 2:30 back in 2017? Like, why was that in your mind and what you reported? Did you change your height and weight in the fishing license database? Was that you? I mean, little things. That's a little thing, but the round in the hope chest, the 40 caliber Winchester that the state's trying to, you know, bring out like it's some kind of link, like it isn't one of the most common common brands of ammunition in America. What's that for? Why did you keep that? What's that about? Why is that in your hope box? They would love to have answers to these things. It's not that they can't decide the case without them, and that they couldn't decide the case in Mr. Allen's favor without them, but it's normal. It's normal for them to want to have those questions answered. And so, if at all possible, I like to be able to give that to them. If I have confidence in my client's ability to show them that, to give them those answers, to be honest, and to be forthcoming, and to just be brave. You know, it's a hard thing, very hard thing. It would take an enormous amount of courage for Mr. Allen to get on the stand. It's a whole other side of it. Is he mentally ready for that after everything that he's been through? Really tough call. So I can't answer that question if it will help him or not. Those are the things that I would be considering, you know, if I'm his attorney. That's all the stuff that I'm taking into consideration when I'm deciding what I'm recommending to him. Lisa Thomas, wouldn't Holeman want to know where Richard Allen parked so they could look for bloody evidence, etc.? Thank you for exposing the rot. Yeah, you would think so, wouldn't you? That would be an extremely important detail for the investigation. Where did he park? It's weird that Mr. Holeman is now trying to kind of back off from, he parked at the CPS lot. That's been in their warrant affidavits. You know, that was one of the suspicious circumstances, the fact that this car was backed in a strange place where people don't usually park at the CPS lot. Very suspicious. Overlooking the fact that this apparently looked nothing like his car. Yeah, you'd want to know where he parked, not just for, I mean, certainly for bloody evidence and stuff like that, but, you know, yeah, to be able to try to trace his steps. We live in the surveillance era now. There's cameras everywhere. People have Ring cameras on their driveways that you know, go out to the street. You can see stuff go by. They're going to want to know stuff like that. Mick Bartnick, the defense did go through 2E process. They wanted to call FBI agent Horan to talk about the cast geofence data, but state got it excluded. Okay. Well, hopefully they have more. I do know they got the geofence data excluded. I still don't understand the reasoning for it. It's beyond my comprehension. Why it's unreliable. It's more than tower data. I don't think even primarily tower data. It's primarily GPS location data. But they have not, like they have with the third-party culprit, where they made the request to incorporate the hearing testimony and evidence for their offer of proof for appeal. They have not done that the same with the geofence stuff. And so it does make me wonder, are they optimistic that the door is being opened for that? Possibly. Possibly the door can be opened for it. They can renew it. I mean, the thing about these motions, these preliminary motions, is that they are preliminary. And so in and of itself, that motion, you can't appeal her denying it. You got to ask her again at trial to let it in. That ruling is basically just saying, until you get permission from me, you can't mention it. So like, you can't bring it up in your opening, and you can't do any questioning about it. You have to go back to the court. And it's when she says no in court, that's the decision that you get to appeal. So her decision in court is supposed to be based on everything now that has been elicited in the trial up to that point. And that can be very different than what she knows or thinks she knows about the case at the time of the pretrial hearing. I remember seeing a line in the transcript somewhere. I don't remember who it was, if it was Rosie or Baldwin, but they said something to the effect of, with all due respect, Your Honor, you don't know anything about this case. And, you know, I do. You gotta wonder if maybe a little light bulb's coming on. We haven't even got to the defense case yet, but So the circumstances can change. The door could be opened, and so I wonder if they are maybe hoping that that's going to still come in, and if not, they'll make their offer of proof. Maybe they'll do it the same as before, where they bring it in, or maybe they will take the time to put it on the record in public. If it wouldn't take very long to call the guy and say what it has to say and who he is, and you know, how he got excluded from the from the investigation by the locals and stuff like that. Yeah, maybe that's worth taking a little bit of that precious defense time to get that out and have that as part of the public process. KDog 8173. If need anything, let me know. 8 miles away. Offered Bob a drone footage of area. Licensed. Surprised FAA hasn't shut the area down, but they haven't. Yeah, that is a little bit surprising that they haven't shut that down. I will definitely be in touch. KDog 8173. Let me figure out how. Maybe drop your email in the chat or something like that, and we can reach out. I definitely appreciate your willingness to help. Star Crazed. If there is a hung jury or mistrial, will Richard Allen go back to jail? Yes. Yes, he will. He will have, typically you have an opportunity to revisit conditions of release and bail and stuff like that. But given these crimes and the seriousness of them, the role that plays in things like setting bail, it's unlikely it's going to be set at a level that he would have a realistic prospect of making it. Maybe crowdfunded. It's possible. I don't know. So that could be something that they could possibly pursue, is seeing if they could get the bail lowered. But I would not, the default is not that he gets released. The default is typically that he goes back to jail. Truth Seeker, change.org for the petition. Could Ahmad post link? If they can hunt that down, we can probably do that. Law and Lumber. At some point, you'll encounter the legal system. Traffic stop, criminal charge, you or family, landlord-tenant, custody, divorce, etc. The stats make clear you'll encounter the system. Andrea is part of a solution. More access, more info, more knowledge. Thanks, Rob. It really means a lot. It really means a lot coming from you. I really, you're one of the good guys, and I appreciate what you do. You're like me. You're a truth seeker, and I really value that. I value that perspective, and thank you so much for that. Buru Berries, grateful for your detailed coverage, a breath of fresh air in between all the speculation and bias that he was charged, therefore he must be guilty. Yeah, the rush to judgment, not my thing. It's not my thing. It's pretty much the opposite of my thing. I'm a skeptical person. I'm a skeptic by nature, and that's part of why I've landed in the role that I did on the defense side of things. I question things, and I think that is reasonable and that is scientific. It is scientific to question things and to require proof before I accept it. So I know that that's not universal, but I've been very heartened to see so many other people out here who have that same perspective. It really is, you feel less lonely when you know other people look at things the same way that you do. Carazola X, got here late. Did any officers lie under oath? Well, it's not looking good. There's been some setup. There's definitely been some setup. There's been some excuses, some explanations that really defy credulity. Like how stupid do you think we are? That kind of thing. Yeah. J Beans, it almost seems like them girls were meeting someone, especially since Libby was being catfished. Did they sound panicked? Maybe they met someone. None of this makes sense. Appreciate you. It seems like a possibility, it's not a possibility I would rule out. I don't know. I don't know. I can't say that there's like anything particularly in the video that necessarily would make me think they're expecting someone there. Um, like I said, all I really got was that part where Libby is saying there's no trail here. It seems like she's explaining to somebody, somebody else who, I don't know, bridge guy, somebody else that's there. But it seems possible. I guess I would just question. I would expect if they were meeting somebody there has to be some sort of evidence of that being set up. And so you'd expect that to be in the phone or in her devices or in her iCloud. And it doesn't seem to be there. But the defense has planted that seed about the ability of certain extractions to recover deleted files. So, could be something that maybe we're waiting to see more in the defense case. Gonna have to be patient, I guess. Jeremy Morton has gifted 20 Andrea Burkhart memberships. Oh my goodness, you have turned the entire chat green. Thank you so much for that. Really appreciate your support. Niall Enterret, thank you for your persistence and professionalism. Now your motion has been dismissed. What other legal options are available to open up the case to the public? Well, I am looking at pursuing the next steps with my motion. That's going to be the most immediate option that we have. If we're not successful that way, then ultimately, I don't think we're going to probably have a lot of choice, but waiting until the trial is over and then getting access to as much as we can at that point in time. If Mr. Allen is convicted, there will certainly be an appeal. And as part of the appeal, they will order the transcripts of the trial. So they will then become public record and we'll be able to get those. At the very least, the transcripts will become public. I'm curious to see them anyway, just because of the sidebars, just like we had with the Delphi Herd. The sidebars, there's just like so much more in them. It tells you, it fills in so much more of the picture of what's happening at the trial. The exhibits are public records. The rule is that the court gets to manage access to the exhibits in order to basically minimize the disruption to their staff. But they can't just use that as an excuse to deny access to the exhibits. So we should be able to get those as well. I'm expecting there may be roadblocks in terms of they're going to complain that it's hard and it's expensive and it's going to take time, and so maybe we have to wait and so forth. But they are public records, and that is something to pursue. So ultimately, it is something that time should fix to some extent. It should help to make this more transparent, because with time, more and more will come into the public record. It's not the most satisfying resolution, but it's something. It's better than nothing. Poe Honesty, just theoretical. Can the prosecution cut the BG video down shorter if the rest of it included a second man, if they aren't using the rest of it at trial? Not without violating Brady. That would be a major, major Brady problem, because it's exculpatory. It's exculpatory to their theory that this was a single perpetrator and that it was Richard Allen. If there's a second person involved that was on the video, they unequivocally have a duty to turn that over to the defense. And so if they did not do that, if they didn't do that, there's a big problem. There's a big problem. We already had, we had a Brady motion already, but it was based off the lost interviews, the 60 or whatever, witness interviews that all went missing. This would be far more egregious. There would not be a innocuous explanation for how that came to happen. Technical difficulties? No. No, because you knew. You knew and you didn't disclose. Somebody knew and didn't disclose. So that would be a major problem if there was something like that came to light. Comes back to deleted items. They can be recovered. Yep, they can be recovered. Guys, it's crazy late. It is Sleep In Sunday, and I'm going to take full advantage of it. But I am tired. We are through all of your comments and super chats. I appreciate all of you so much. Appreciate you joining me here tonight. I appreciate you sharing my outrage about what's happening here, about what's coming to light, about the treatment of this man and the distortion, the gross distortion of this legal process. It's just been appalling. And I realize that for many of you, you're like, yeah, hi, Andrea, we've known this for a long time. I appreciate that. I really do. Today was the day that it unfolded in the courtroom, and seeing particularly just the courtroom's tolerance for this kind of thing. That's a big part of what gets to me. That's a really part of what has gotten me so worked up about this. So horrified. This is the process. So thank you all. Thank you all for joining me. I am very, very grateful. I really do appreciate all of you. Rob is still here, gifting the Burkhart memberships, turning the chat green. Thank you, Rob. Thank you on behalf of everybody who got one of those. You are the real MVP. All of you guys, everybody who has rallied, the line sitters, the mods, all of you in the chat, all of you showed up to view, who have taken an interest in this case and who care about what is happening here in Delphi, Indiana, care about justice for Abby and Libby, and justice for Richard Allen. It's not a zero-sum game. Justice is not a zero-sum game. Justice for one person doesn't mean less justice for another. It's a lot like love and compassion that way. You can have compassion for crime victims and also have compassion for perpetrators. It's all possible. There's no limit. Don't limit yourselves. Oh boy. A couple more here. Michigan Farm Boy, any thought about warrantless geofence being limited due to Fifth Federal Circuit ruling not constitutional, even if they are in the Sixth Circuit? This would be potential grounds if it were the defense trying to exclude it. They could certainly raise that argument. But if the defense wants to introduce it, the state doesn't get to argue, we violated your rights, so you don't get to use that. It's the state that committed the violation. So they're the ones that suffer the consequences from that. The defense can essentially waive that violation for purposes of their own case. So I don't see, now granted we are talking about Judge Gohl, and could possibly be more creative reasoning there, but yeah, I don't see that being a particularly viable argument from the state to keep it out. Rob is over here. Law and Lumber still gifting the Andrea Burkhart memberships. Rob, you are really outdoing yourself tonight. Law and Lumber, guys, he's amazing. He does fantastic work. He does his Friday his Friday stream, which is a lot of fun. I've been over there a couple of times. We always have a good time. Rob and I, we connected during Delphi Herd, as so many of us in this little corner of LawTube did. And I've always had great respect for Rob and his opinion and how he breaks things down. Excellent attorney and upstanding, salt of the earth, good person. So go check him out at his channel. Lisa Thomas, RA's phone is missing, but he was on a device to look at his stocks after he parked. Where's their metadata? Also, the bullet inspectors couldn't replicate the marks on one try. Not a match at all. Apples to bananas. Yeah, I mean, that's the bottom line. They did what they said Mr. Allen did to the cartridge, and they couldn't reproduce the effect that they say Mr. Allen got when he did it. You know, replication is one of these kind of fundamental scientific principles. If you can't replicate it, then you got to question it. So that's a big problem. Yeah, the absence of data is curious. It is curious. If he was on the phone looking at his stocks while he was out on the trail, you would expect him to connect to the tower. And they know his identifying information for his phone. So you'd think they would have been able to identify that. But it seems from the questioning that they have not. They've acknowledged they don't have cell tower data that puts him in that area. It's a bit strange. It does maybe call into question the functionality of the cell tower. And if that's the explanation for some of these discrepancies, why his tower, his phone doesn't show up in the tower, maybe the Abby and Libby's phone going on and off. You know, these are possible explanations. State didn't investigate it, didn't look for answers to those questions. Be interesting to see if the defense did or not. Slovak Girl 94 with a super chat. Thank you so much for that. I am signing off now, guys, for real. Please don't send in any more super chats. I'm ready to go to bed. Thank you all. Thank you for your support. Thank you for being here. Today's notepad was, because it was a short day, it's about what we would expect. It's about half a notepad. So I did try to take down pretty much everything that I could. It was a lot today. And like I said, there was also stuff very hard to hear once his voice got so quiet. There was stuff that I missed, but still plenty to get down there. So another half a notepad here. I'm putting my notes together over the next couple days too, for some of these interviews and stuff like that. So, Andrea needs 100K subs before Friday Night Frenzy next week, please. Rob, you're like my biggest fan. I love you, man. You're awesome. Thank you so much. So, y'all have a good night. I'm gonna go get some shut-eye now. Enjoy my sleep-in Sunday. Check me out on Grizzly True Crime tomorrow afternoon, 3 o'clock Eastern, if you want to continue to follow the updates on this case and what I'm up to. There'll be chance for questions and things like that. We'll be going over just some of the basics of the case and just, you know, what has transpired over the last couple of weeks since this trial started. So find me there. Thank you guys all so much. Appreciate all of you so much. Appreciate all of your support. You guys are the best. You're the reason why I'm here doing this. And you boost me up and give me the energy and the enthusiasm, the encouragement to keep doing what we're doing. So we'll be back at it next week. Back bright and early Monday morning. Look forward to it. Seeing what we get next. Maybe one of these days we'll get some evidence. We'll get some good evidence that Richard Allen is guilty of this crime. You think? Maybe? Maybe. We'll wait and see. A lot of trials still to come. Take care, guys. I will see you on the flip side.